Jeffrey Rother, sir, thank you.
Yes. You may proceed. You ready?
Thank you. Thank you and good morning. May it please the court, my name is Jeffrey Rother. I'm with Morningstar Law Group and we represent the appellant Epcon Homestead LLC. I'm asking to reserve 5 minutes for rebuttal. The question before the court today primarily is whether the district court erred in its determination of the accrual date of Epcon's claim under 42 U.S.C. 1983. Epcon was the owner and developer of a residential real estate project in the town of Chapel Hill. Epcon's claim arises from an affordable housing fee payments that were made to the town as required to receive certificates of occupancy for homes that were constructed in Epcon's development. Following the payment of those fees, Epcon filed suit for their return. In addition to state law claims, what's before the court today is a claim under 42 U.S.C. 1983. The claim is premised on a taking of Epcon's property without just compensation in violation of the takings clause and a government deprivation of Epcon's property in violation of its right to substantive due process. The district court dismissed the claim under Rule 12b-6 on the grounds that those claims are barred by a 3-year statute of limitations. The court concluded that Epcon and its affiliates knew of their alleged injury in October of 2014 when the town issued a special use permit which quantified the amount of fees that would be due when the homes were finished. The court's view was that time that the claim accrued because Epcon could foresee its future obligations.
Wait, and why couldn't it foresee its future obligations to make the payment?
Well, it could certainly foresee its obligations.
So then why was it not aware of its injury at that time?
The difference is the district court did not distinguish between anticipated and actual injury. And that's the standard that's at play here. An expectation of a future injury is not relevant. The Supreme Court has made clear that accrual occurs when the plaintiff has a complete and present cause of action, that factual and legal prerequisites for filing must be in place. The 1983 claim at issue here is under the takings clause and a violation of substantive due process, and both require a deprivation of property. It was not until those fees were paid that Epcon actually was taken of its property without just compensation. And it wasn't until those fees were paid that it was actually deprived of its property. An expectation of losing your property in the future without just compensation or without due process of law is not sufficient to bring a claim for violation of those constitutional rights. If Epcon were to have sued for money damages before it paid those fees, the town certainly would have argued that those claims were not ripe and that Epcon had not sustained any injury at that time. Moreover, the Supreme Court recently clarified in Nick that a 1983 claim generally is not available for injunctive relief to prevent a taking because a monetary remedy through 1983 is available after it occurs. So although perhaps the injury was foreseen and perhaps a declaratory judgment claim could have been made, it wasn't until that property was taken that a 1983 claim, the claim that's at issue here, was available to be brought. That is the time in which it accrued.
When did they become obligated to pay the fees? I know the permit issued before they owned the property, but was it once they owned it or once they started building? And I realize we're here just on the complaint. So if the answer is the complaint doesn't say, or, let me know.
The special use permit is attached to the complaint incorporated by reference. The obligation to pay the fee arose as a condition of receiving certificates of occupancy.
And that's on every 7th house?
Correct. The certificate of occupancy is after a home is built. The government needs to review it, inspect it, make sure that everything is okay for someone to live in it. So it was not until such time that they were asking for someone to live in these houses that the fee was paid. So it was made a future condition of receiving those future certificate of occupancy permits.
Were they allowed to start building? I guess I'm wondering that there was no obligation to pay until the 7th house was done and you wanted a certificate of occupancy, but were they allowed to start building house number one without having, promised to pay in the future?
Certainly, Your Honor. It's alleged in our complaint that construction began and the fees were paid afterwards, after the homes were built,
Right.
in order to obtain those certificates of occupancy.
Okay.
There was no, it's not, certainly not in the complaint. I'm not aware of any bonding or any other obligation that they became on the hook.
When did your client agree to pay?
I'm sorry, I
When
couldn't.
did you agree to pay it?
There was no agreement to pay them, Your Honor. There was.
It wasn't? You didn't proffer in terms of your prospective development that we're going to do this and such, we'll be able to buy down the normal requirement to make homes affordable to certain people. You can pay extra money. Didn't you agree to do that at some point way before they start building those homes?
It was a choice, Your Honor.
I know,
Yeah.
and that's what I'm asking you. When did you make the choice?
The choice of one of EPCON's affiliates was made at the time of the special use permit proceedings, and that was in 2014, I believe. The special use permit was in October of 2014.
So at that point, you were injured because you were forced. Now you're telling us to endure these harms because it's more than money. Because you could have just made a money claim. You could do that, but you're making a 1983 constitutional claims. Isn't your injury when they said, you didn't mean to tell me I got to agree to this extra money just to make sure that people, you don't have to have these affordable homes if you pay this extra money? Weren't you harmed then?
No, sir, and I'll
not?
explain why. Because the special use permit is permission to move forward. It's not an obligation to move forward. Land development in particular is full of contingencies and uncertainties, and we all saw that in 2008. At the time they received that permit, they received permission from the town to move forward to build this development. But they were on our...
That goes back to Judge Rushing's question. They didn't have permission to start building, it sounds like, unless they agreed to be obligated to pay the fee.
They had a special use permit that provided them the opportunity to build this development. And as under the town ordinance, they had a choice. They could have dedicated land, they could have sold affordable units to certain classes of people, or they could have given up money. In either such circumstance, it was a future obligation to give property to the government or to someone the government has identified, which is a per se taking under this court and the Supreme Court's jurisprudence. And to get back to Judge Gregory's point, this area of business in particular is full of contingencies and uncertainties. The market could have crashed, and this land could have laid there without development for years, and it could have been sold, it could have been redeveloped, it could have been rezoned for a different use. These special use permits have a 2-year life. If they didn't start building in 2 years, the permit expired, it could have gone to a different use, it could have been sold to someone else. In all of those scenarios, no fee would ever been paid, no dedication would ever been required, there would have been no loss. And the accrual standards, whether it's under 1983 or across the board, recognizes the difference between these anticipated and actual injuries. In a contract case, a party can be aware that it has a dispute about a future obligation with its contractual counterparty, but it's not until that there's a breach and there's an injury does that claim accrue.
You have an injury with real estate, for example. If someone tells you, you own the lot and you want to build your house, and they tell you, well, wait a minute, you can build this lot, but you have to put up a 6-foot stone wall around the back of your property. And you haven't paid for it yet, but when you go to your lender, you have to factor that additional cost in, and they say, wait a minute, well, you're above your budget now. We'll okay this for this, but now the wall comes in, it's going to cost another $20,000. That's injury, isn't it? And you haven't paid a dime because, am I right or wrong?
I think you're wrong, Your Honor.
Okay, tell me why.
In your scenario of something with the land, it requires to be built on the land in order for it to be developable for single family or something like that. I can see that. That cost has to be anticipated.
I'm wrong because you can see that, but you can't see that.
A buyer will know that that improvement has to be made. But here we're talking about an obligation for specific use, a specific housing development that EPCON proposed to build on this property. If the property is going to be developed through retail or industrial, for example, there would be no obligation for this fee payment. If someone wanted to buy this large lot for their mega mansion and build just one home, no fee would have to be paid. There are multiple scenarios where this land could have been used in a way that would not have triggered these obligations to the town. And that goes to the point, in the fact that EPCON chose to use the property in this way does not make it some way that they're consenting to the loss of their constitutional rights. I mean, the court in the Horn case, or the Supreme Court case in Horn, Department of Agriculture, explained recently that businesses cannot be required to give up property as a condition of entering the marketplace. And that's certainly what has happened here. The fact that EPCON chose to build once it knew of this obligation does not affect necessarily the nature of its claim or when that claim accrued. It wasn't until there was an actual deprivation of property without due process of law, without just compensation, that its claim for monetary damages accrued. What I'm arguing before this court is nothing new. The court has applied this principle in the context of 1983 cases arising from government development fees. The Tommy Davis construction case that's cited in our brief, the court stated without any need for further discussion that a 1983 claim for the recovery of fees accrues at the time those fees are paid. And that makes sense because that's the time that the government deprived the plaintiff of their property. It said in this case, the period began when Davis Construction paid the impact fees. The city's case or the town's cases are inapplicable because they're different types of cases. The town and the district court failed to distinguish between two types of cases that arise under the takings clause. There are regulatory takings cases in which the government deprives a property owner of the present use of the property, where the allegation is that the property itself has been taken for the inability to use it, versus the type of claim that we're making here, which is a per se taking for the appropriation of property for the government or for someone else. And the distinction between those two types of claims is important because it dictates at the time the claim accrues. In a regulatory taking case, the alleged injury is to the value of the property. So once the regulation is finite and known and the government takes its position, that is the time that the property is injured. Here in a per se taking case, no property is taken. No claim accrues, and there's no alleged violation of the takings clause until such time that the property is actually taken. The national advertising case that the town cites and the district court cites is a very different matter. It was a nonconformity case where there's an ordinance that required a billboard owner to either take down its billboard or to change it to comply within 5.5 years. And the town says, well, look, this case is exactly the same because they foresaw that that 5.5 year period would happen, and it's the same situation here. It's not, because that ordinance in national advertising impacted the present use of the property and the value of that property at the time the ordinance was enacted. The alleged injury of a regulatory taking and the ordinance application happened at the time the ordinance was enacted, not in the future here where the per se taking only occurred later in the future within 3 years of the time that EPCON filed its claim. So I see that I'm running out of time. Unless the court has any additional questions, I am going to ask to reserve 5 minutes.
I want to just before you sit down, make sure it's clear so other side can address the question if they need to. So you're saying that this is illegal, requiring this proffer for this purpose is illegal?
Yes, yes, Your Honor, both under state law, which is not before the court today, and also it's a violation of the Fifth Amendment and the 14th Amendment because it violates the principles under Nolan and Dolan. The court has made clear that there must be a nexus and rough proportionality between.
And what's the standard review in terms of constitutional idea, in terms of the taking? Compelling interest, state interest, or strict scrutiny, or what's the standard?
The standard under Nolan, Dolan, and Kuntz is that there must be a nexus and rough proportionality between the property that the government is seeking from the permit applicant and the impact that to the public that the development is expected to have.
Would you agree that adequate housing is a problem in our country?
I would.
Affordable and adequate housing is a problem in our country. Do you agree with that?
I would agree with that, Your Honor. But there is.
Do you agree that this goes to trying to make homes more affordable to people?
I would agree that is trying to make particular homes more affordable for particular people, making a housing developer pay roughly $80,000 per unit in order to build more homes doesn't seem like it will affect the price of, reduce the price of other housing. It would only seem to increase it. But to your point, Your Honor, the difference, the Constitution looks at both the means and the ends. And that's made clear in Horn, that's made clear in Cedar Point, that was issued last year, is that just because the government might have a legitimate ends, the Constitution still protects the means to get there. And the Nolan, Dolan, Kuntz all make clear that the Takings Clause prohibits government from making particular businesses or particular people bear the costs that society should try to solve on their own.
What class of people are you protecting? You said particular people.
I'm sorry, I don't understand your question.
What class are you said protect, shouldn't put the burden on particular people. So what class of people are you saying are burdened by this?
Well, if the town wanted to raise funds for affordable housing, it could certainly increase property taxes and raise revenue through other means. What they've done here is put a condition on housing developers to dedicate property to either the town or to a specific group of people to subsidize housing for those people. And that's, although the town might have ends, an objective or a goal that may be important to the public good, that doesn't mean that they can use whatever means necessary to get there. The Constitution.
You think the town is being Robin Hood?
I'm sorry, Your Honor.
You're saying the town is like Robin Hood. In that sandwich argument, you said they're using you to pay for something else for common good.
I think that's right, Your Honor.
That's what Robin Hood did, didn't he?
I wouldn't use that analogy, but what I could see your point. I understand the analogy.
I'm trying to follow you what you're saying, because you said that they're trying to put this burden on a particular type of people in order to address a certain type of problem. So I just want to see what you're saying.
Certainly. The point is that there may be a problem. Housing in the town may be too expensive. That's not before the court. That's not part of our pleadings. The point is that no matter what the ends are, whether they're legitimate or illegitimate, the means to get there still must be within the bounds of the Constitution. And they have taken means to get there that imposes a per se taking on residential real estate developers, including EPCON, which in a manner that violates the Takings Clause. Because Nolan and Dolan make clear there must be a nexus and rough proportionality between the government demand for property and the impact that is expected from the development. And to build more housing, housing like anything else is dictated by supply and demand, right? My client was building more houses, increasing supply for the town's housing base. That does nothing to increase prices. If anything, it reduces them. So to say that EPCON must pay money or dedicate property or give something to the government for the right to build more houses to help eliminate the problem is exactly the gimmickry that Nolan, Dolan, Kuntz, all the cases in this exaction territory state clearly that the government cannot do.
Okay, thank you so much.
Thank you.
Mr. Hartog.
Thank you, Your Honors. Good morning. May it please the Court, Dan Hartzog Jr. on behalf of Town of Chapel Hill, the appellant in this matter. Your Honors, this is a case that is essentially a unconstitutional conditions case. What
He said
appellant,
you violate the Constitution,
that's their claim, Your Honor.
and that's why I want you to speak to it. He said that's what you've done, and the cases are clear. So
Well, that is
speak to-
certainly their claim.
And I'm asking you now to respond to it. Get to that.
I don't believe we have violated the Constitution. I believe this is a valid use of land use. And as we've said in our brief, density and affordable housing is certainly an important government interest. What the Town of Chapel Hill is attempting to do here is to make sure that affordable housing is available for its workers and other people who, live in the town. And, supply and demand is the issue here, and supply is limited. Land is limited, housing is limited.
Well, explain to me how those ends are accomplished in charging this profit in these circumstances here. Just tell me how that's accomplished.
So the way the program works, Your Honor, is anyone who develops a certain number of single-family houses, I think it's above 5, is required to dedicate a certain portion of those to low-cost housing. Or, in the alternative to doing that, they can pay a fee in lieu that the town can use to make affording housing.
Help me with that. Let's say if the average house they were going to build, this is hypothetical, the average house that was being built in this development proposed is $500,000. And let's say they didn't pay the premium to be exempt from this requirement, and they did have the 7th house, what would that house cost?
I don't have the exact price, Your Honor.
No, I mean, how does it work? How much is it reduced? I mean, in other words, you're saying you're making it affordable, low cost. I would think that means that someone who has less funds could buy in that $500,000 category of homes in that neighborhood. So tell me, because he's raised a constitutional question, he said your means are not appropriate. So I'm asking you, how do you get to your reason, your justification, and I assume it's compelling or reasonable or whatever, in my hypothetical? Is it they pay 20% less than what that would be? They pay, what, $400,000? I mean, tell me, how does that work? Because that's what, as I understand, Mr. Rother is saying, you putting this burden on us, and what are you accomplishing? How does that work?
Well, what we're accomplishing is that every new development, every large new development that comes into the town has some percentage of housing that is more affordable. And I apologize, Your Honor, I don't have the exact numbers of the discount or the low cost.
But can you even tell me there is a discount?
Yeah, the general idea is that you have to make it,
I'm not talking about the general idea.
yes, there would be a
You're
discount.
here facing a constitutional challenge. You should be able to tell us that the compelling reason is accomplished because that person can get into that $500,000 neighborhood and pay less money for that 7th house,
Well, part of the,
other than just going to the county's coffers. Tell me how that's accomplished.
what it accomplishes is.
No, not what it accomplishes. How is it accomplished?
By requiring the developer to make
To
some
pay
of
you
that.
money.
To either make affordable
To pay you money, because in this case, they
is-
paid you money, right?
that is an alternative.
But they paid you, wait a minute, they took the alternative, they paid you money, right?
Yes.
How is that going to make the 7th house cheaper for the person who is meant to be helped by the reduced low-cost housing? That's a simple question. Maybe I'm missing something in my question, but isn't that what you're supposed to be doing today? Telling us why the Constitution is not violated because there is a compelling or rational basis for this program. What is it, and how is it accomplished?
So the fee in lieu, you're correct, Your Honor, would not make that 7th house more affordable. What it does, it gives the town the ability, it gives the town funds to use, and it's not in the record currently because we're at the 12B6 stage, how exactly the town uses the funds to make
But
affordable housing available,
you want us to affirm the dismissal, right?
based on the statute of limitations, Your Honor, yes.
Right.
That was the decision of the district court, is that their claim, to the extent they have made one, arose in either 2014 or 2015. So I don't think the panel needs to reach a decision on the underlying merits of the program, because this claim is
Well, he's saying that they weren't injured at the time that the district court said that they were, because it was merely an expectation of future injury. And in our Tommy Davis case, we said that a 1983 due process claim accrued when the plaintiff there paid the fees. So why isn't that applicable here? That the claim does not accrue until they pay the fees?
because in that case it's different, because in that case it was the application of an ordinance that is a general ordinance that would not have applied to the plaintiff itself unless and until they applied for the permit and were required to pay the fee. What we have here is the ordinance was applied to the plaintiff back in 2014 or 15. At that point, and this is from Kuntz v. St. John's River Management District, a U.S. Supreme Court case from 2013, in that case, what the court said is you cannot condition a government benefit on some exaction, on a payment of a fee.
But didn't Kuntz recognize that there's a difference between the conditional permit and the actual taking, right? I thought I read in that opinion that the court acknowledged that this is not to say that a condition on a permit actually takes something, but it's an unconstitutional condition sort of claim. But once something's taken, they acknowledge that that's different.
What they said was there was a constitutional injury at the time that the condition was imposed, that the constitutional violation as alleged in that case, and that they didn't reach some of the merits of the case.
Well, maybe that's acknowledging that plaintiffs could have had a different claim, right? Plaintiffs could have tried to bring a permit conditions claim, and you would have had ripeness challenges, et cetera, but they didn't. Instead, they brought a takings claim, a straight-up takings claim, right? Because you actually took something. Is that a distinction that we acknowledge in this context?
I don't believe it is, Your Honor, because the taking in this case is, I mean, the constitutional violation that they're alleging is we were required to pay this fee because of this program that was applied to us.
Let me ask you, what keeps tripping me up is that how can there be a taking of property, which is, real property, when they don't own any property? They don't own the property. So this permit was granted with the condition before they owned the property, and then the complaint doesn't specify exactly when they got it. It says some in 2015, 2016, which unhelpfully for you straddles where the statute of limitations cutoff would be. How could there be a taking of property if you don't yet own the property?
I think what they alleged in their complaint is it was their agent who obtained the special use permit. So I think they are bound by their agent.
Sure, but how, at that moment, how could there have been a taking in 2014 when none of the parties who are interested, who this regulation was imposed on, none of them owned the property, right? So the government could say, if you ever acquire property, one day you might be required to pay it to us, but they didn't own any property at that point.
And that's why the district court made the distinction and said it either arose in 2014 when the special use permit was issued based on it being their agent, or it arose in 2015 when they purchased the property. When they purchased the property, they were aware of the special use permit. They were involved in the process because it was their agent who obtained the permit. At the very least, when they came into possession of the property, they had the right at that point to file an appeal and challenge the constitutionality of the special use permit and say that this requirement that we have this condition to either dedicate low-cost housing or to pay a fee in lieu is unconstitutional. And so that...
But would you have brought, there would have been ripeness arguments about that, right? Did they file this appeal? Were they actually going to use it for this purpose?
I think so here's how I look at it. I think the injury was present in 2014 and 15. The damages that flow from that injury increased as they paid the fee. but the injury itself and the constitutional condition, allegedly unconstitutional condition imposed on them was imposed on them in 2014 or 15. So when you've got a takings case, what you look at is the government's action. You don't look at the plaintiff's action, you look at what the government did. And what the government did is require them to pay this fee in 2014 or 15, depending on when they purchased the property. So, when they made a payment in 2017, you look at, okay, what government action required them to make this payment? It's the special use permit that was issued in 2014 or 15. There was no new government action requiring any payment after 2014. So when they say, well, we
that
wrote a
argument
check.
I'm not necessarily disagreeing with you that there might be some sort of claim that could be made then, but I worry about the implications of this argument that, as a citizen, for instance, I know I'm going to have to pay certain fees, right? Like if I, go to a particular government agency and I'm going to have to pay a certain fee, and I can foresee that, but I haven't actually paid it, right? Because I haven't taken certain actions. And to say, well, you paid it today, but you knew that this law was enacted 10 years ago, and that if you ever wanted to avail yourself of the privileges of that law, you were going to have to pay that fee. No one thinks it accrued 10 years ago. How's that different?
Because if you're talking about a general ordinance or a general thing that applies across the board to everyone, but it doesn't apply to you until you apply to take advantage of the program, then that's when you are injured. So in the impact fee context, the cases that plaintiffs have cited in the impact fee context, that is a general ordinance that is applicable to the entirety of the population that doesn't get applied to you.
No, some of those were pretty specific, right? It was like you had to get approval for a certain development to hook up to the water, utilities, and it wasn't just as a matter of course, right? The developer went and had to find out, does this apply to me, and what am I going to have to pay? Those seemed a little more similar than you give them credit for.
Well, they do apply. If the developer might have asked questions about how the ordinance applied, but that doesn't change the application of the ordinance and the legal application.
That's like this. I mean, everyone knows this regulation applies to anyone who wants to build in a certain way, but it doesn't actually affect your pocketbook until they say, I'm not going to give you a certificate of occupancy unless you pay me X dollars.
So I think you're correct in that in 2013, they couldn't have brought suit challenging the ordinance and saying, we're planning to develop and we know this is going to be applied to us. And on the front end, before it is, we want to challenge it because there's no injury. Here, what they did was they did apply, they got the special use permit, the ordinance was applied to them, they knew to the penny what they were going to have to pay. So it's different than a general ordinance that doesn't apply to you until you take advantage of the program. This is a specific application of the ordinance to plaintiff. And at that point, that is the injury, the alleged injury, the government applying the ordinance to you, requiring you to do something that you contend is unconstitutional.
Yeah, you agree it's not like national advertising though, right? Where that's a regulation that we said it encumbered the property, right? This permit restriction doesn't run with the property, right? You can use it for other purposes, or they could have not purchased it, et cetera. That there's a mismatch with that case.
I agree that it's not an exact match, Your Honor, for that reason. But the point, I think, of national advertising is that it is the government action that you're looking at. The government action in national advertising was the requirement that you remove this billboard. That is when the injury occurred, not when they actually had to comply. And I think the same kind of analysis is here. The injury occurred when they were required to make this payment pursuant to the special use permit, not when they actually complied with the special use permit and made the payment.
Well, you said, you might want to rephrase that. You said the injury occurred when they were required to make the payment. Now, they weren't required to pay the day the permit came out, right? They were required to pay if they wanted a 7th certificate of occupancy, right?
Right, which they sought and received. So I agree that they could have decided not to develop and they wouldn't have had the same amount of injury as far as dollar amount, but they had the same injury in that they had a allegedly unconstitutional condition imposed on their development. And that is what Kuntz said is a constitutional injury that is available to redress. And Kuntz specifically said it doesn't matter that they paid no money, that there was no actual loss of money.
Because in Kuntz, they were denied a permit, right?
Correct, they did. But the injury was the unconstitutional condition, not the payment of a fee or anything like that. And the same thing we filed this morning, and I know Your Honors have not had a chance to see this, but we filed a 10th Circuit decision that I believe is analogous here. In that case, there was a sidewalk requirement. The city said if you want to expand your business, you have to build a sidewalk. They issued that requirement to them in 2014. In 2016, the applicant got that amended to say, well, you can do the sidewalk or you can pay us a fee. And they filed suit in 2018 within 2 years of the fee requirement, but not within 2 years of the original requirement to build the sidewalk. And the 10th Circuit recognized that the injury was the requirement to comply with the regulation requiring the sidewalk. And they said your claim is barred by the 2-year statute of limitations because you knew back in 2014 that you had this obligation. And I think it's the same thing here.
If they had decided not to build on the property, would they owe the city any money?
No, but it's not, again, it's not the payment of the money that is the injury. It is the requirement imposed on them to pay the money as a condition for building. So it's the condition, and that's exactly what Kuntz held. It is the unconstitutional condition that is at issue here. And the other distinction between this case and an impact fee case is the impact fee case is a straight up fee.
What was the name of your 10th Circuit case?
Your Honor, that is 2701 Mount Glen Court, LLC versus City of Woodland Park. It's a 2021 10th Circuit case. We filed a supplemental authority this morning. The distinction here between the impact fee cases is this was a fee in lieu. And what that means is you have the choice of doing the affordable housing units or you can pay the fee. So the application of that choice that you have to do one of these two things, and as a condition to develop, was imposed on the plaintiff in 2014 or in 2015 when they purchased the property. So they knew what the injury was. They could have.
The injury was the condition, not the payment.
That's correct, Your Honor. And that is exactly what Kuntz held. It doesn't matter that you didn't pay any money. It doesn't matter that there's not any actual taking here. What matters is that you were required to do this condition. That's what Nolan-Dolan applies to, is does the required payment, have the rough proportionality to what you're doing. All of this could have been litigated in 2014 or 15. It would have been the exact same legal arguments. It would have been the exact same analysis. The only difference here is that they went through with the permit before filing their suit. They weren't required to do that under Kuntz and under the.
Again, Kuntz was acknowledging that you don't have to have an actual taking, right? Because the permit was denied in that case, and the court said, we acknowledge, you can have this unconstitutional conditions claim that you were denied a permit because you wouldn't give up these other constitutional rights. And that's a valid claim under Kuntz, but it's not the only possible takings claim that can be brought, right? The court didn't do away with traditional takings claims where you own property and the government demands to take part of that property. And those are different.
Yeah, well, the demand to take the property was the special use permit, and that's.
But they didn't take it until it was actually turned over to the government, right?
They didn't receive it until it was turned over. They took it when they made the requirement. When they said, you can't do this. You can't do what you want to do. You cannot build your units unless you pay us this fee.
They put the restriction.
That's when to the extent there's a taking, that is the taking. Because again, no action taken by the government after that point. So when they wrote a check in 2017 or 18, what you have to look at is why did they write that check? What government requirement forced them to write the check? And what it is a special use permit, which is different than the impact fee cases when they wrote the check and you said what required them to write the check. It's the application of the ordinance to them at that point. So the government action in the impact fee cases was when they wrote the check, because that's what the government said. That's when the government said you have to write us a check. Here, the government said you have to write us a check in 2014 or 15. It doesn't matter when the plaintiff actually wrote the
To
check.
loop back, that's what you say is the distinguishing factor with Tommy Davis construction case.
Correct. And the quality built homes case relied on by plaintiffs as well. I heard plaintiffs' counsel argue in response to Your Honor's question, what is illegal is this requirement that we do this. That's what they say is illegal. That's what they say violated their rights. That's what occurred back in 2014 or 15. And so, I think the district court applied the correct law, and we certainly believe that the taking, to the extent it occurred, we deny that there was a taking. We think this was a valid land use regulation, but we didn't really reach that issue at the district court because of the statute of limitations. I think it's the same thing here. Unless Your Honor has any questions, I believe I'm out of time.
Thank you, Mr. Hotdog.
Thank you.
Mr. Rother, you have some time reserved.
Thank you. I'd like to address a few things that came up. First, the 10th Circuit case that was filed this morning, I haven't read it. I just found out when we walked in here this morning that it was there, but I will say this. Without having read it, a sidewalk is infrastructure. So that's something that's typically required to be built during a project. So it would make sense to have a present obligation at that time, so that the requirement for the improvement was present. It's different than what we have here, which is a payment at the end of a project. Taking didn't occur until the very end. The concept of whether we had an opportunity to bring a claim back in 2014 or 2015, I think is a bit of a red herring, because it would have been a different claim. Statutes of limitation don't accrue for different claims all at the same time. It's not a transaction or occurrence test, it's when a claim accrues. And the difference between Nolan, Dolan, and Kuntz, those all came to the Supreme Court from cert on state law proceedings.
How would it have been a different claim?
Because our property wouldn't have been taken without just compensation. It would have been perhaps a state law claim for declaratory relief to prevent a future injury. A 1983 claim that we brought here.
At that point, that's what the obligation was if you built the property.
That's correct, but we have a system with accrual that accrual does not occur when we know something might happen in the future. Accrual occurs when there is an injury and there is a complete and present cause of action. Judge Rushing said exactly what the court observed in Kuntz is just because coming out of these certiorari from state law proceedings, they were looking at whether the dedication, the taking, if that occurred, would it have violated the takings clause. This case is different because we actually went through with it. We paid the fee and we said, you took our property, now I get it back. It's a different set of circumstances, and even the court, Judge King in concurrence in Kuntz made clear that everyone was in agreement that no taking actually occurs, and there's potentially no claim for damages until that fee or the dedication or whatever it is made. And the accrual standard that we have is there for good reason. I mean, even when disputes are real, the injury may be uncertain. I mean, we have a system that allows parties to wait until they suffer an actual injury, an actual deprivation of their rights or a loss of money or whatever it is before they have to seek redress for that. The implications are enormous in a system in which a party's time to file suit is tied to a date on which it understands that it could be injured in the future. Litigation is not fun. It is not something that people do until they find it absolutely necessary. And that is why our system is set up the way it is. I mean,
It seems to me all of the elements of a claim is there. The condition is on you, and you had to satisfy the condition by making a promise. And that promise was quite quantifiable because you knew the exact amount. What else would be left in terms of, if the condition is burdening you, you know what the burden is, and you know the response was you had to promise to pay it, and you know how much you had to pay. Why wouldn't that be a present and clear injury?
Ronald, I'll take on one piece of what you said, which was a promise. This is not a contract. This is a permit that gave us the opportunity. And the town said,
You didn't promise to pay?
we were given a choice. And we took the choice of least resistance.
You always go back to choice. Okay, you did have a choice, but once you make the choice inured into a promise, didn't it?
A promise implies that we would have had to make that payment regardless. And we understood that fee would have to be paid if the project went forward. And that was not a certainty in 2014.
You promised to pay. You did.
We accepted a permit that required that payment to be made if and when we requested certificates of occupancy. The point is, Your Honor, the claim under state law or whatever it is to try to remove that condition is a much different thing than a Fifth Amendment takings clause claim under 83 to seek redress for a taking that has actually occurred. Just because we had a different claim.
I'm not sure you haven't taken it all, but I'm not sure about that, but that's not before us, I guess.
And the Supreme Court and Nick made very clear that with a taking, there is no requirement to exhaust administrative remedies. It would be an odd standard if our time to file a taking claim post-deprivation would be tied to some kind of administrative remedies pre-deprivation process that we have no obligation to undertake in the first place. So, Your Honor,
I disagree with your colleague who said that you could have, the municipality has a process for you to appeal it, and if you win, then you could proceed without paying that money. Do you disagree with that?
I'm sorry, Your Honor, I didn't understand.
Counsel said that there's a process for you to redress this through appeal. You heard, did you hear that?
Yes, I understand that. I don't want to get into the intricacies of land use under North Carolina law.
You're getting into what I'm asking you.
Yeah, understood.
All right.
The point is, whether we had a right to appeal under North Carolina statute is independent of whether we have a right for compensation for the taking that occurred 5 years ago.
No, it has a lot to do with your whole theory of when your claim accrued. It has to some degree. If you don't think it does, that's fine.
Your Honor, I would say it certainly would dictate when any state law claim may have accrued, but it doesn't affect when my federal takings claim for a completed taking has occurred, because there is no taking until I've actually I give up any property. Well, I see that my time is out. I'm happy to address any other questions. If not, I thank you all for your time.
Some of your close. You have to take 30 seconds to close if you like, because I took some of your time.
I just wanted to thank you for your time. I'll ask that the court reverse the district court and remand for further proceedings. One procedural point, the court declined to exercise supplemental jurisdiction on the grounds that all federal questions had been dismissed. So I think if the court does decide to reverse, I think the proper procedure here would be to
Mr. Dave?
Good morning. May it please the court, my name is Richard Lev. I represent the appellants. The district court erred in granting summary judgment. There's no basis for granting summary judgment here. Whether a mark is generic is a question of fact. The USPTO approved my client's application to register Gruyere as a certification mark, and the defendants opposed that application. By opposing that application, they assumed the burden of proving that Gruyere is generic. If the defendants are unable to meet that burden of proving it as generic, the mark will be registered. So what does this burden entail? To show that a mark is generic, the statute has to be followed, and the statute says the test for genericism is what is the primary significance of the mark. Defendants had the burden of showing that the name Gruyere is perceived by a majority, because we're talking about the primary significance. Is it perceived by a majority of consumers to mean a type of cheese that can be made anywhere, as they claim, or does it mean a cheese that comes from my clients, namely the groups in Switzerland and France? They admit that majority understanding is the test for genericness. So they had the burden of showing that there's no factual dispute as to what a majority of consumers believe, and they failed both to show what a majority of consumers believe and to show that there's no factual dispute. They failed on both counts. First, they failed to prove that a majority of consumers understand Gruyere as generic. They don't dispute that a survey is the preferred method of showing genericness in this court. Yet they offer no excuse for failing to provide one.
Well,
They
just
not
because
only
it's
failed
the
to-
preferred method doesn't mean it's the only method.
No, it's not the
Correct?
only method, but it's definitely the preferred method. And they also offered no evidence of consumer testimony. So the evidence that they did produce is ambiguous and ambivalent. And they also failed, and this is important, they failed to acknowledge the Supreme Court's statement in the Booking.com case that because genericness depends on consumer perceptions, quote, difficult questions may be presented when a term has multiple concurrent meanings to consumers or a meaning that has changed over time. And they don't cite a single case where a court in this circuit has granted summary judgment on genericness where the mark was alleged to have become generic over time. Here, the district court said that the meaning of the mark Gruyere has changed over time, and the district court found that the mark means different things to different people.
When it comes to changing over time,
Right.
do you agree that if a mark becomes generic, there's no going back? It can't become distinctive again?
Sure. It doesn't happen often, but it has. The mark Singer was somebody's name. It became a trademark, then it became generic, and now it's a trademark again. It can happen. If a term, but all the cases they cite are cases where the mark was always generic. It was generic from the beginning, like freebies for goods that are free, or Crab House for a seafood restaurant that specializes in crabs. But this case involves what the district court said was a case of genericide. It was a good mark. It represented cheese made in Switzerland, and it became generic over time. Not a single case do they cite where this court has found genericide on summary judgment. In fact,
What are the factual findings that you contend that the court made improperly, since this is at the summary judgment stage?
the factual findings that the court made are, well, first off, the court didn't make any finding as to what a majority of consumers understand the term Gruyere to mean. The other factual issue the court made was the court seems to have accepted the other side's contention that you can just weigh the cheese, which country produces more cheese under the name Gruyere, and the court made several factual issues in connection with that. First, they downloaded a spreadsheet from the U.S. Department of Agriculture that shows different categories of customs duties. Apparently, there's a customs duty that has in the name of the customs category Gruyere processed cheese. Why it says that, we don't know. But that's not how the cheese is labeled. The district court jumped to the conclusion that said every cheese imported under that customs category is labeled Gruyere. There was no evidence of that. And the court then jumped to the conclusion that millions of pounds, and the majority of cheese comes from places like Netherlands and Germany and Austria and Egypt and Czech Republic. Where are the labels that say that? Where's a label that says this is Gruyere cheese from the Czech Republic or some of these other countries? That was clear error of fact. The court also
This would be a bench trial,
correct.
right, if you got beyond summary judgment, where the court would be the fact finder. So what's the practical difference in the court finding facts at this stage versus a bench trial?
Well, the practical difference is first, there has to be, first, the court can't grant summary judgment here. There are errors of fact and errors of law, and there are facts in dispute. So the court can't grant summary judgment. What happens next, we don't know. I mean, obviously, these factual findings have to be reversed, and if we get a decision from Your Honors that these are errors of fact and law, then we go back to the...
Can we say that there are errors of fact and law, or would we be simply reversing because it was improper for the court below to make factual findings at the summary judgment stage?
You can do several things. First, you can say the court could not have granted summary judgment because there are issues of fact in dispute. There's issues of fact as to what a majority of consumers think. There's issues of fact as to consumer perception. So first off, there shouldn't be any summary judgment. But in the course of that, the court made errors of law. The court said the FDA regulation permits the use of Gruyere on this cheese. The FDA regulations don't permit anything. They just say that if you put Gruyere on cheese, you have to make it in accordance with our standards. Okay, fine, but it doesn't permit anybody to use Gruyere. That's a question of trademark law. And there was an error, excuse me. It was an error of law for the district court to say that the FDA standard permits the use of Gruyere on this cheese. So that should be corrected. It was an error of fact for the district court to say that this spreadsheet they downloaded from the U.S. Department of Agriculture, all the cheese listed on that, all the cheese referenced on that spreadsheet is labeled Gruyere. That was an error of fact. So this court can say, A, summary judgment should not have been granted. B, the court below made errors of fact and errors of law. The one case, I just wanted to mention one thing. The one case that the parties cite, which involved this alleged process of genericide, is Glover against AMPAC. In that case, the plaintiff sued for infringement of the trademark Whitetail for knives. The defendant counterclaimed to cancel the mark on the ground that Whitetail was generic for knives, and they put in evidence of third-party use, like they did here, of third-party use of Whitetail. The defendants put on an expert witness who identified these third-party uses, and this court said, still, that mark is not generic. The expert witness acknowledged, quote, I'm quoting from the decision now, the expert witness, quote, acknowledged that he did not perform any consumer surveys and was not able to testify to the public's understanding of Glover's trademarks. So that's the same here. When genericide is an issue, when the issue is what do consumers believe over a passage of time, you've got to have evidence either in the form of a survey or consumer testimony or something to tell the court how consumers perceive this give The other thing is, the other issue is that
I guess when we use the phrase genericide, it's kind of assuming what consumers thought originally, right? The district court said, you know, this may have begun as a distinctive mark because this Gruyere, you know, originally was made in this region. But the question for distinctiveness is not, was it exclusively made in this region as a fact, but is that what consumers understood? And so we're kind of assuming that at some point in American history, you know, Americans understood and believed that all Gruyere came from this region. but that over time that belief changed. But there's really no evidence about what Americans believed, however many decades ago, right?
Well, everybody agrees that Gruyere has been made since 1100 A.D. And-
Yeah, but that's not the question for
Well,
distinctiveness, is
It's
it?
been made there since before there was the United States, before there was Wisconsin, before there was a cheese industry in Wisconsin.
Yeah,
So the only thing it could have
You're
meant.
right. I'm just pointing out, this is not determinative of your case. I'm just pointing out an interesting oddity, I think, which is we're all assuming that you can show at some point in American history that, the primary significance of the term was that Gruyere was imported from Switzerland and France, but we don't have anything to prove that. We're really just talking about, as of the date of this application, what is the primary significance
I think
in the
it's-
U.S.?
As of the date of now, as of the date of summary judgment or trial is the issue.
Right.
And I think that that's the process that the district court himself said was going on. It meant one thing, and now it means another thing. And there's been no case where that issue has been decided on summary judgment. The only things that have ever been decided on summary judgment are these marks like freebies or crab house, where they've always been generic. And then there's another factual issue is perception of these labels. There's a label by Boar's Head Cheese, which buys cheese in Wisconsin and labels it. They don't label it Boar's Head Wisconsin Gruyere. They label it Boar's Head Blanc Gru Gruyere. They give it a French name, and they say it's old world tradition. Down at the bottom in the fine print, it says Wisconsin. But the district court made a finding of fact that people will look at that label and see that it's made in Wisconsin. That's a finding of fact. That's an inference in favor of the other side, where on summary judgment, you should be making an inference in my client's favor. That kind of thing, how do people perceive fine print on a label? That's not for summary judgment. The same with some of these other cheeses where the country of origin isn't even shown on the front of the label. You have to flip it over and look at the fine print on the back to see where it's made. That's an issue of fact, and the court should not be saying as a matter of law that people will see this and see that it's made in Wisconsin. Similarly, the Wegmans grocery chain, which sells three kinds of Gruyere, intense, medium, and mild. The intense and medium come from Switzerland, the mild comes from Wisconsin. The labels are pretty much the same. And the court said as a matter of law, people are going to understand that two of them come from Switzerland, one comes from Wisconsin. That's an inference in favor of the other side, not in favor of my client. That's a question of fact that has to be decided at trial. And the other thing I would add is, to the extent that expert testimony is needed, the date for selecting experts has passed. They don't have any expert testimony. It's too late for them to put in a survey. It's too late for them to put in any kind of expert testimony. Discovery is over, except for one limited exception. I said they could take the deposition of my client's chief executive from Switzerland when he comes for trial. But aside from that, discovery is over. So they can't add to the record. The record is what it is. They just cannot support their case. And then I just want to talk about the evidence that they put in place of a survey. The preferred evidence in this court is a survey. The less preferable would be things like dictionaries and press articles. The dictionaries, even the other side concedes that the dictionary evidence supports both sides. We have the Encyclopedia Britannica, which says Gruyere is made in Switzerland. We have the comprehensive Oxford Companion to Cheese, which says it's made in Switzerland. It's one of the greatest cheeses in the world. They dismiss that. They say, well, it's a European cheese guide. It's published in New York City. It's not a European cheese guide. And then the articles they put in, the newspaper articles, these are old articles dating back to before, more than 9 years ago, before Emmy Roth stopped using Gruyere. A significant producer of what they used to call Gruyere stopped 9 years ago, and yet they continue to say they still use Gruyere. That's not true. I think I'll reserve the rest of my time unless you have any additional questions.
Thank you, Mr. Lake. Ms. Sarsky?
Yes, good morning, Your Honors. My name is Nicole Saharsky. I represent the U.S. dairy groups today. It's undisputed that for decades, U.S. cheesemakers, starting with the Roth Company, have been making and selling Gruyere in the United States. That dates back to the 1980s. And also for decades, there have been massive amounts of non-Swiss and non-French Gruyères imported into the United States and sold as Gruyere. And we provided data on that in the record, as well as labels to show exactly what consumers are seeing when they go into the store to buy cheeses, including Gruyere. And based on all of that voluminous evidence in the record, first, the Trademark Trial and Appeals Board, and then the district court in this case found that Gruyere is generic for a type of cheese. The TTAB found no doubt on that score in a precedential opinion, which doesn't happen very often. And then the district court here at the summary judgment stage, applying the summary judgment standard, said this evidence is overwhelmingly one-sided, such that no reasonable fact finder could look at the state of the world as it exists in the U.S. marketplace today and find that Gruyere is limited only to this small region of Switzerland and France. And so, one of the things that I want to address is the legal standard here, which the consortiums say is a majority of consumers survey type test. That's not correct. So the legal standard, which is in the statute, which I think is the starting point for all of us, this is in 15 USC 1064 Part 3, is the primary significance to the relevant public. And everyone agrees here that the relevant public are cheese consumers, people who buy cheese in the United States, whether it's retail, wholesale, restaurants, whoever else. And that primary significance standard is understood to be a look at really consumers as a whole and the whole marketplace. It's not understood as some type of numerical test that requires a consumer survey. It's really more of an overall totality type judgment, the kind of judgment that courts make by looking at a lot of different factors all the time. And there are some kind of classic sources of evidence that this court and other courts have looked to figure out, like, what is the primary significance to the registered public. And two of those key sources of evidence are, first of all, are others, other than the people claiming the mark, using this term in the marketplace for just a type of cheese in general. And we know that that's true both with U.S. consumers.
Isn't there a dispute of fact about genericness at this point that the district court can't resolve at the summary judgment stage?
So the historical facts in terms of imports or labels, et cetera, there's no material dispute there about the numbers or how the labels look or anything like that. The thing that is disputed is the ultimate really legal question, which is, does this all add up to genericness or not? And that is a factual determination for the court to make. It's one that's reviewed for clear error after the court, for example, makes that decision after a bench trial. But this court has said in many cases, actually, that even though the ultimate question of genericness, that how does it all add up, is a fact question to which the court gets deference, that it can be decided on summary judgment. And actually, most of the cases from this court and the other courts of appeals were decided on summary judgment. So that includes the retail services case that we cited in our brief. It includes the Institut National case, which involved the genericness of the wine product Chablis, which came from the Federal Circuit. Pretty interesting and case that's very similar to ours. It involves the Colt case from the First Circuit, which has to do with a type of firearm. The Booking.com case that this court decided that then went and was affirmed before the Supreme Court, that one was a genericness that was decided on summary judgment. So it's actually pretty well established that even though the ultimate question of is it generic is a fact question, that often is decided on summary judgment when the court finds that the evidence is overwhelming one way or another. And so I think it helps to kind of look at what the court had before it in this case. Just going back to what I said are those classic sources of evidence, you've got massive amounts of U.S. Gruyere being produced since the 1980s, sold by the Roth Company as Gruyere in the United States. You've also got large amounts coming in, specific amounts documented in the record, with labels from companies like Boar's Head that brings it in from Germany, or also Dietz & Watson, a company that brings it in from Germany, and saying that there are just these millions of pounds of Gruyere in the market every year. And the interesting thing is that even though that's been happening for decades, it wasn't until 2012 that just the Swiss consortium, not the French, just the Swiss, even did anything to try to control the use of that mark. And frankly, their efforts were really too little, too late, and just not very effective. They tried to get some producers to stop using the term Gruyere. Many refused. And then actually, the thing that we think is telling and that the district court thought was telling is that they actually entered into a contract with the Roth Company, which is the huge producer of Gruyere in Wisconsin, and said that when they sell it to private label customers like Wegmans or Trader Joe's or whoever else, that those companies can go ahead and label it as Gruyere. So this is evidence that's come up in other cases, like what is the person claiming the mark for themselves, like what is their conduct in the marketplace? And when their conduct in the marketplace is go ahead and use this term for Wisconsin cheese, that's like pretty good evidence that the mark isn't limited to just that specific cheese and that specific place of origin. And so, when you've got not only the U.S. producers, the foreign producers, them themselves saying, go ahead by contract and use Gruyere for this Wisconsin cheese. You also have, for part of that time, the Swiss consortium undercutting the French consortium and saying the French cheese doesn't count. So between the two of them, there had been a historical dispute as to even what, in their view, the mark meant. And then you add that to, the common usage evidence and the industry usage evidence that the court went through, really a voluminous amount of it. It just led the court to this inescapable conclusion that, even if there were a couple dictionary definitions.
What's your response to his argument about the fact that you didn't have a consumer survey?
So this court has said in other courts that consumer surveys aren't required. They're just one possible source of evidence, and any competent evidence can be required. And actually, a lot of courts, including most recently several justices of the Supreme Court in the Booking.com case, have really cautioned the use of consumer surveys because of the ability to manipulate them, and also because of that they often lead to a battle of the experts, that courts put kind of too much weight on them. I mean, in this case, we had these other really key sources of evidence that we thought were overwhelming in terms of just the flooding of the U.S. market since the 1980s and 1990s of the U.S. cheese labeled as Gruyere and as the foreign cheeses labeled as Gruyere. So under those circumstances, we didn't think that a consumer survey was required. And this court has actually, even when there have been cases where there were consumer surveys, the court has rejected the survey. So it's not like the survey that would be like the Huntmasters case, for example. That was about a mark called Crab House. Someone was trying to register Crab House. So, the survey is just one piece of evidence. And here, the court was finding that all the evidence was really pointing in this same direction.
Following up with Judge Thacker's question to you, you said at the beginning, it's the relevant consumer. And therefore, it's sort of a curated customer base who knows about the cheese and those things. And I'm not one of those people in that relevant consumer base. So, but isn't that why surveys are more important? And you said battle of experts, but don't you need some sense of expertise in the genre of the cheese? And like for example, you talk about going back to the 12th century, Switzerland and France. It's a sort of a connoisseur type market. Isn't that more of a need, and as opposed to something that's more generically so in this case?
I mean, it's all of the relevant consumers, and there are some that are more sophisticated, like the large purchasers at restaurants who look for very sophisticated cheeses. There are some cheese consumers, like myself, when I go to the store, who are perhaps a little less sophisticated. But the question is, when they see the word Gruyere, do they think that's a type of cheese, or do they think it's cheese from only a particular place? And the labels that they see in the store and the way that various competitors and the consortiums themselves are behaving in the marketplace is evidence of consumer understanding. I mean, it's not the case you can survey every single consumer in the U.S. So consumer surveys, or every consumer of cheese, which is the relevant group here. So, surveys have limitations, and I think that's why this court, in a number of cases, and other courts, have looked to this marketplace evidence of labels and the like. For example, there was this case that the court had a while back called Royal Crown Cola, and it had to do with Coke wanting to register zero, like for Coke Zero and the low or no calorie Coke products. And one of the things that the court looked to there was evidence in the marketplace of who's using this zero mark. And lo and behold, it's not just Coke, it's kind of a widespread understanding for sodas. And so, there are a lot of cases, I guess, that are decided without consumer evidence based on this more overall sense of what's happening in the marketplace and what consumers are actually seeing when they go into stores. I'd also point the court, this is a case from the Federal Circuit, but I think it's useful. It's the Institut National case. It was about Chablis, like the wine product Chablis, and whether that's generic for a type of wine or whether that's just limited to a particular place. And there, the kinds of evidence that the court looked at was, what's out in the marketplace? What was the mark owner's own use of Chablis? Were they kind of taking efforts to protect the mark, or were they using it in a generic sense? They also looked at some government regulations, which is another thing that the district court thought was a relevant factor here. And then they looked, for example, at the trademark registration history, which, as we pointed out here, this isn't the first time that at least the Swiss consortium has tried to register that Gruyere mark. And of course, the PTO found that it was generic then. And as Judge Rushing pointed out, once a term becomes generic, it is very difficult, if not impossible, to have it become non-generic. That's something this court has said, for example, in the Booking.com case and in other cases. And so here, starting in the 1980s and 1990s, you've got just this massive industry that's built up in the United States, based on the hard work and ingenuity of the folks at the Roth Company in Wisconsin, and then other places like the cheesemakers in Idaho, other companies in Wisconsin. And those folks have been making this product in the U.S. Market and selling it for decades. And what the consortiums are asking for here would really just take this whole word off the table. It's an extraordinary thing that they want. They already have this specific mark to say, Gruyere from Switzerland, right? They can use this design mark to say Gruyere from Switzerland. But they want it to be the case that no one can use this word at all, even though it's been used for so long in the United States by all of these companies. And that's just an extraordinary thing that's just not justified on this record. The only other thing I might say is that, this is something that's happened to a lot of cheeses, actually, that they were originated in some place like cheddar. That originated in Cheddar, England, or Colby, which originated a place in Wisconsin, or Gouda from the Netherlands. That, of course, they started in a place, but over time, it's been understood that they refer to a type of cheese. And that's what the district court said happened here. He didn't say, there was no evidence in the record, to go to Judge Rushing's question, about before 1980. So we don't know what U.S. consumers thought before 1980 about Gruyere or any other cheeses. But what we do know is that once there was this production in the U.S. and these other imports, that there came to be this understanding in the U.S. that despite their fairly limited efforts, that the consortiums just couldn't establish that that the word was limited to this particular place. And so what we're asking for here is really just to affirm the district court's grant of summary judgment. The district court issued look through a voluminous record. We've got all the volumes of it here. That's just a summary, and went through the undisputed factual findings. To the extent the consortiums are suggesting that the court found facts, the court, I think, was very careful as to say what was the facts that were undisputed. And the court was very careful to say, I'm not saying, for example, that all the imported cheese is necessarily labeled this way, but here are the companies that provided me with data in the record, like Boar's Head, like Dietz and Watson, from the U.S. cheeses like Wegmans. I mean, it's very specific numbers in the record. And he says that tells me that this non-Swiss and French cheese is just pervasive in the U.S. marketplace, and it has been for a while. And in light of that, plus all of this common usage evidence, plus the FDA recognizing through the standard of identity that this is just a very common cheese of a particular type in the United States, I just can't say as a reasonable fact finder that you could find that it's not generic. And by the way, if we were going to go forward, I would have to do a bench trial, and I just can't see the fact issue to decide. And that was really the consortium's burden here. What is the genuine issue of material fact for trial, other than the ultimate question of genericness? And I just don't think that they've identified one. There are there are arguments about the evidence, like, well, does it really show this? Or kind of conclusory denials, like, we disagree. But the court said, here's the evidence of genericness. Tell me what's on the other side and point me to the record citations. If they say if the sky is blue and you say it's red, tell me where you're joining issues so I know if I need to have a trial. And I think the problem for the consortiums here at the end of the day is that there wasn't that joining of evidence. The historical evidence is, there's really no material dispute on it. And in light of that, kind of seeing the decades of U.S. usage here, the court thought it was reasonable to grant summary judgment against the consortiums here. I'm happy to answer further questions if the court has them, but otherwise, we'll just ask the court to affirm the judgment of the district court. Thank you.
Thank you, Ms. Saharsky.
I may briefly respond. I wanted to start by talking about what counsel first said was the test for genericness. She said, this may not be word for word, but she said, it's an overall totality we have to look at. She said, it's a judgment that has to be made looking at a number of factors. That doesn't sound like summary judgment to me. That sounds like fact-finding to me. That's what counsel is saying. She's saying you have to look at all the evidence and all the facts and then make a decision as to whether Greer has become generic. You can't do that on summary judgment where there's issues of fact and dispute, and there's errors made in making those decisions. As Judge Gregory said, this is a specialty product, a connoisseur product. You can't decide whether this term has become generic on summary judgment without a survey, without any evidence as to consumer perception. And basically, their only reason for not having a survey is because they don't want a battle of experts. Well, that sounds like they don't want a trial. They don't really want to decide this issue and find out, has this cheese name become generic like some, or is it not generic like others? That's something that has to be decided at a trial. It would be difficult, in my view, to decide this even at a trial with expert witnesses, which is too late for. To do it on summary judgment is just wrong. This is not a summary judgment case. Let me respond to some of the specifics of what counsel said. She talked about the Chablis case. The Chablis case involved a mark that for wine, which is in the jurisdiction of the Bureau of Alcohol, Tobacco, and Tax, I think it's called, which is specifically charged with geographic designations for wines. There are statutes in this country on geographic designations for wines. And Chablis has been held and the BATF has said it's a semi-generic designation. And there are other registrations in the Patent and Trademark Office for wines that use Chablis in the name, and they've registered it with Chablis. So it's a totally different case. The FDA, which has standards for making cheese, has no jurisdiction over geographic designations. That's not their job. They don't know anything about what the consumers know about the names of cheese and what the names of cheese mean to consumers. That's not their expertise. As for whether Roth, the company in Wisconsin, ever said to stores, go ahead and use it, they never said go ahead and use it. They said, don't use it. They were diplomatic. They didn't want to get into a trademark fight with their own customers, but they don't own the trademark. Roth in Wisconsin doesn't own the name Gruyere. That's owned by my clients, and they enforce it. They wrote to all these stores and said, don't do that. Some of these stores complied. Some said, we're waiting for the outcome of this case. Counsel mentioned some sort of dispute between France and Switzerland. The French side of the border now has the Gruyere designation, and they've been given rights in Europe. So they filed a new application where both parties are the applicants. And they have an agreement between them that Gruyere from France will be labeled Gruyere from France, Gruyere from Switzerland will be labeled Gruyere from Switzerland. And as to enforcement in the United States, that's the responsibility of the Swiss entity, which is much larger. Very little French Gruyere is actually imported into the U.S. Most of it is sold in the domestic market in France, so it's really not a significant factor. The last thing I would say is, counsel is saying this word will be taken out of the vocabulary. That's not true. There's no need to use it. All the artisanal cheesemakers who make award-winning cheese in the United States have no need to use Gruyere. They come up with other names and they're perfectly happy and they're proud of it. They don't need to use Gruyere. If this were a generic term that people needed to use in the United States, you would see XYZ Farms, Vermont Gruyere or New Hampshire Gruyere or whatever. They don't do that. They come up with other names and they're happy to do it. What would happen is that consumers, if this were declared to be generic, consumers would be harmed because a certification mark tells consumers that this name means a cheese is made in traditional methods in Switzerland or France, and the cheese has the characteristics of the region. It's handmade by these farmers who have been doing it for 900 years. That's what this certification mark tells consumers. If they have their way, and this becomes a generic term, then any factory, any place could make a bland, waxy, tasteless cheese and call it Gruyere. That would confuse and harm consumers. Thank you.
Thank you. Thank you both, counsel, for your arguments. We can't come down and greet you, but know very much that we appreciate your being here and helping us with this case. And I wish you well and stay healthy. Thank you. Ms. McLaughlin?
Thank you, Your Honor. May it please the court, I am Jim McLaughlin, and I represent Mr. Ivy. With me is Alexis Narducci. First, we would like to discuss the show-up question here. And what's important about the show-up is that virtually all federal appellate courts, including this one, have criticized show-ups on a variety of grounds, most predominantly because they are suggestive and therefore generally unreliable. But there are very, very few cases in which the courts have granted relief with respect to a show-up, because there are a variety of factors that they look at and they find under the totality of the circumstances, it's simply not either sufficiently subjective or there are other indicia of reliability. The question is this a case in which we are on the other side of the line? And we would respectfully suggest that we are, because of a couple of very, very specific factors in that totality of the circumstances. In the general context, however, I'd first like to note that if one is constantly saying you should not be doing this, but actually never say you were wrong to do it, one cannot be surprised if that behavior which you are trying to deter continues. That is a problem with show-up identifications. What is different here is several factors. Most trenchantly, the detective who did the investigation's conduct. That detective told each of the 14 people who came for a show-up that Mr. Ivy looked like the suspect, and he, in fact, had been captured. That direct statement to influence the outcome.
Well, just to be clear, she said that he fit the description of the suspect, right? Not
Yes.
looked like.
Well, he fit the description. If the officer has told you he fits the description, then naturally the overwhelming suggestiveness when the man is standing there in front of the
Taken
police
out of the cop car in handcuffs, then the suggestion is,
Exactly.
right, he does fit the description. That must be why he's in a cop car with handcuffs.
And that's why my natural answer is, sure, that's him. It looks like him. Ironically enough, the one witness who testified at the trial, but like both witnesses, was not asked to identify Mr. Ivy at trial, simply said in response, apparently, that he looked like the guy. Didn't say that was the guy, in essence parroting Detective Hopkins. The second factor here, I think, is almost more disturbing, and that is Detective Hopkins in her testimony made quite clear that she had the ability to record her discussions with each of those who was to identify or attempted to identify Mr. Ivy, and could have recorded their actual identification process. Instead, she made the decision, and we respectfully suggest it was a knowing decision in light of the guidance of the courts, not to record any of her communications with the person doing the identification prior to them actually looking at Mr. Ivy. She did not record any of their comments with respect to Mr. Ivy, or the time it took to identify him, or how certain they were, or anything else. After the identification process, she put the person back in the car and then asked them the simple, pointed question, did you identify him? Why is this critical? It is critical because you have a police enterprise here taking all of the factors that you would consider, how certain they were. What prior description had they given? What other comments did they make? And taking affirmative action to make sure that information was unavailable to you. Those two factors, in and of themselves, the first and second, are sufficient. However, if you look at the reliability issue in addition to the suggestiveness, you also have these factors. You have a room or an interior that was, quote, extremely dark, as defined by the first police officer on the scene. Indeed, it was so dark that he did not see the body of the victim on the floor and tripped over it. The evidence with respect to this bar is, in addition to being extremely dark, it had strobe lights and a variety of other things that would interfere with an individual's ability to identify the assailants, who, in fact, were either masked or hooded. So there is an...
What do you say to, Mr. Johnson said he stood in the bar area, which is well lit because there's a cash register. I think maybe the entrance, there were two areas that were well lit. What do you think about that?
I think the definition of well lit under these circumstances is open to question. The second thing is, when one is moving rapidly across areas that are not lit and lit, the issue that was identified, which the expert who was excluded would have testified and actually was commented on in the court, is it is not merely about the lighting, it is your eyes adjusting to the lighting. You come from a lit area, you go into a dark area, you can't see. You come in from a very dark area into a very light area, again, your eyes have to adjust because everything's bright and it's difficult to see. And so when you look at the totality of the lighting and the circumstances, the mere fact that there was a particular part that was well lit, and one of the assailants may have been in that part for a relatively brief period of time, I think does not overwhelm all of the other factors, and again, in the totality is not sufficient to make the identifications reliable.
So the district court used the fact that the vast majority of the people that were taken to the show up did not identify appellant. The district court used that to say that it's some proof that it wasn't a suggestive show up. What is your response to that logic?
I think that is a remarkable exercise in self-justification. There is no scientific or other evidence that would indicate that because 85% of the people cannot do an identification, the two who did identify in response to a suggestive show-up are reliable. In fact, it should be exactly the opposite, that the two who did identify the assailant were in fact influenced by the suggestiveness, and the other 14 simply held on, particularly where here you have, for example, the woman witness who testified to a variety of different descriptions and a variety of different factual circumstances to justify her identification. And again, the male witness who simply said, well, he looks like the guy, didn't actually
How should
defend
we
him.
weigh that? Because you're right, their testimony was not, it wasn't overwhelming, right? He said it was, I'm 15 feet away when you asked me to identify him. It looked like the guy. And then she said, left side, right side. But that was all in front of the jury, right? So the jury heard that and they were cross-examined on, doesn't that make you why should we trust your iffy testimony on that? How does that weigh into how we analyze this question?
I think the fundamental answer is found in the analogy to the rules of evidence, and that is, yes, a jury can weigh lots of different factors, and the jury may or may not be qualified or not to do that, particularly when, as here, there are a variety of psychological factors and observational factors that science identified that a juror would not be familiar with. But nonetheless, the courts with the rules of evidence in here say it is so, 403, it is so prejudicial, unfairly prejudicial. This is so unfairly suggestive and so unfairly unreliable that therefore the court's obligation is to put an end to the practice. The other problem, again, is, a la the exclusionary rule, if you want to deter people from going as far as they did here, that's it. The other thing is the jury didn't know or couldn't understand the impact of the detective not recording or making any record of all of the other factors I've discussed, where, in essence, they have cut off judicial review. That has an independent significance a jury could not appreciate. The other things we have here, I think...
Assuming this was error, why is it not harmless error, considering all of the other evidence against appellant, particularly with respect to the robbery?
Two factors, Your Honor. First is that the statistical evidence and the scientific reviews show that the testimony of an eyewitness is generally deemed by a juror to be more persuasive than a variety of other factors. And so that would create, you take those identifications out of this case, and you have a very, very different case in front of the jury. The only thing you have then is, well, there was a card, which we're separately going to talk about, that may have connected Mr. Ivy to the crime, and you have the issue of he was in the truck when it was found, when it was identified. And so...
Wasn't there also DNA?
Your Honor?
Wasn't there additional evidence other than him just falling out of
the
truck?
issue of whether the question was whether he was in the truck. There was no DNA evidence that I recall that would have identified him as being in the building. I may be wrong, but I don't think so. I think it's just connecting him to the vehicle.
Yeah, but to the clothing that was in the vehicle?
To the clothing that was in the vehicle.
That witnesses to the hoodie that was in the vehicle?
That's right, Your Honor.
And didn't witnesses describe the offenders as wearing a hoodie?
One of them, yes. But a hoodie is very common.
And then there was the money too, right?
I don't believe,
Wasn't there cash found?
yes, there's 180, he had $186
A lot of it in ones.
in ones and
And
20s.
this was a strip club that was robbed, correct?
It was.
But he was charged with the robbery, but also, convicted, but also the murder, the use of a firearm and that resulted in death. Was there any evidence that he had, that gun was his?
No, they didn't find a gun, Your Honor, and so there is, in fact, no evidence. And, it is purely a circumstantial case there with respect to, well, there was a card that was on Mr. Youngblood, and so therefore there's some connection there. And you have Mr. Bishop who pleaded.
Hard.
And so there is, as Your Honor has rightly identified, there is a tremendous dearth of information, of evidence that would beyond a reasonable doubt connect him.
Co-defendant testified against him? Pled guilty and testified
Pled
against him?
He
And said
pled,
he
yes,
did it?
Your Honor. If you look at, Mabine and Hancock, the two recent decisions on show-ups, I think, and you go through those factors, this case, again, is the extraordinary case where you have that. And I want to just, mindful of time, the fact that the court excluded the expert here simply exacerbates the problem, where in that district, they've been using identification experts since at least 1996, and that would be the Maddox case in which they had an expert. And there are literally hundreds of cases in which they are identified as experts and used.
Is that Dr. Michael?
Yes, Your Honor.
Didn't the defense tell the district court 3 times that they'd elected not to present Dr. Michael as an expert?
Yes, and the answer to that, Your Honor, is that is not a waiver, because at that point, the court had ruled and said, I'm not going to, and had made the remarkably prejudicial statements he made about Mr. Michael just being somebody who got paid to say witnesses were not reliable. At that point, once the court had ruled, the fact that counsel said...
At that point, you say, we are not calling Dr. Michael because the court has ruled, but we continue to preserve our objection to that.
Yes, Your Honor. You can, and
That's not what happened.
simply said,
Drew attention to this problem and said, if you're not withdrawing, we need to have a record, I need to make some rulings. And they said, no, we're withdrawing.
I think in light of the judge's prior conduct, they could make the reasonable determination that they had already made enough of a record, Your Honor. The next issue is the Miranda issue, and here, I think the most important fact is the persistence of the officers and the fact that no Miranda warning, so far as we know, was given the entire time that he was in the location of over 4 hours. You have the Detective Cunius saying, do you need a medic? Answer, no. If you're going to talk about a well-being exception, or do we need to provide care, at that point it is complete. However, he then goes on to ask about Ivy being in the truck. That then is not enough, because Officer Secund asks these questions again. And so those questions in that dialogue creates the issue of the violation of Miranda with the continued questioning. And I will, having reserved time, I will discuss it in much more depth. I'll use my reserved time for the issue of the question under violent force here and whether we have a 924C issue. Thank you.
Thank you, Ms. McLaughlin. Ms. Ray?
May it please the court, Amy Ray for the United States. I'll begin with the show-up identification. And since that's where Mr. McLaughlin began, I would say 2 things. First of all, you have to have suggestive procedures, and you also have to have a substantial risk of misidentification. Supreme Court has said evidence is for the jury to weigh unless there is a very substantial likelihood of misidentification. And there have been almost no cases that I could find where this court or the Supreme Court have held that the due process right was violated because of the substantial risk of misidentification. In this case, the defendant, the witnesses were all told, it's just as important for you to tell us if this is not the person as it is if it is the person. And that might be
But
why.
that this person fits the description, this person that we're taking out of the police car in handcuffs fits the description.
Right.
And given that nothing, these other things that the officer says she said, was that recorded?
It wasn't, but of course that doesn't go to whether or not the evidence that's actually here. It doesn't render a procedure unreasonable simply because it was not recorded. And what she testified to, and there's no contrary testimony, that she told each one of them, yes, he matches the description, but he might not be the person. And it's really important for you to say if he's not.
Is that what she, I don't remember seeing, and it is really important for you to say that he is not. I remember her testifying that she told him he could be, could not be.
She told him it was just as important for them, and I can find
I remember the just as important.
I
Really
believe,
important, I don't remember.
I believe she did, Your Honor, and I can look to see quickly if I can locate the page number in the appendix. She testified a couple times. She testified both during the suppression hearing and during the trial, and I believe it was in the suppression hearing where she.
What is your best case? I'm sorry but I'll find the testimony. What is your best case that this was not suggestive, improperly suggestive?
It's not, I would say that I haven't found a case that said that a show-up identification where somebody was, handcuffed or whatever, those identifications that take place immediately following the crime are the ones that are both, on the one hand, suggestive because you have only one person.
4 hours after, right?
That's right, but-
Immediately following.
That's pretty close in time, Your Honor. Within 2 or 4 hours is pretty close in terms of and one of the things that the courts have said is it's important in a case when you need to find the culprit if this is not the person.
Officers thought they had the culprit here. They were trying to confirm that this is the culprit. That's why they told the potential witnesses, this person fits the description.
I think
They're
what
not looking for, they think they found the culprit.
they think they found the culprit, but they would need to make sure because if they don't, they need to release Mr. Ivey if they didn't find him. Now, I will say that there's ample evidence that it was Mr. Ivey, even beyond the evidence that this court has discussed so far. So even if, and let me just say 2 things. First of all, I would refer this court to the case of United States versus Saunders, 2007, Judge Michael, who held that, who said that the procedure in that case was suggestive, but that it was still admissible evidence. The exclusionary rule should not apply because it was not so suggestive that there was a substantial risk of misidentification. And the Supreme Court, one of the great quotes that I think is very helpful is, juries are not so susceptible that they cannot intelligently weigh identification testimony that has some questionable feature. The question is, do you take this away from the jury, this identification? This defendant had lots of opportunity to cross-examine extensively, and they did. Judge Cogburn characterized this identification testimony as some of the weakest that the government had. So let's talk about what the government had that was strong. In addition to the fact that they found the Big Mike's phone in the truck, they found the wallet of Randy Hamilton, and Randy Hamilton testified that he was in Club Nicky's and that was his wallet. It was on the floorboard of the truck. They found DNA in the truck that was associated with Mr. Ivey. Both Michael Johnson and Brittany Simmons testified, and also Randy Hamilton, that there were 2 people they got robbed by. One was a much bigger gentleman, and one was smaller. And that it was the smaller person who shot Adrian Youngblood. And of the 2 people that were in that truck, one of whom was Ivey, who was jumping out of the truck, he was the smaller of the 2. And there was a clear disparity. It wasn't close. So we have, and I want to mention, because I didn't do this in my brief and I should have, FBI agent Imel, I believe is his name, he did an assessment of all of the clothing that was seized from DeMarcus Ivey. And when he showed the video, he compared specific identifiers on Ivy's clothing and on Kevin Brooks' clothing, Kevin Bishop, sorry, his clothing, and he compared it to the video that was taken, the surveillance video in Club Nicky's. So there is evidence tying the clothes that DeMarcus Ivy was wearing with the person who was walking through Club Nicky's. It was much stronger than just some ambivalent or slightly, so I would say, yes, eyewitness testimony can be very powerful. I would also respectfully suggest that this eyewitness testimony was not so powerful. So at the end of the day, were the suggested procedures so significantly risking of misidentification that we should take that from the jury? And I would suggest that if you read the cases, you can't reach that conclusion in this case. Not based on the fact that all of the witnesses were told and 12 of the 14 didn't identify him. And the lighting, by the way, just to correct that, Michael Johnson testified that the lighting in that lobby area, when he was told, "Let me in or I will kill you," he said, "I was 2 feet from him and I could see his face. I was 2 feet from him and looking him in the face."
Ms. Ray, as you properly cited Saunders' case in 2007, Judge Michaels, and then you moved along with the other part, harmlessness and other indicia of the crime beyond the identification. But let's take that first part. Here, and one of the things that keep it from being suggestive is that you get as much as you can of a description from the eyewitnesses or the people who are in the club first, so you get an idea of who they perceive, what they perceive. But we don't have any of that because for some reason it's not on the record really what they were told or what they told them. But we do know they said he fits the description. And then you show them a person who's in the patrol car, handcuffed. That's pretty suggestive on steroids, isn't it?
I would say it is suggestive, but I don't think it's so suggestive that it was substantially likely to lead to a misidentification when every witness was said. It's important, if it is not the person, then tell us that. And that description came from the people Brittany Simmons said she called 911. She gave a description. I don't know exactly what that description was. I don't think that is on the record, but what we do know is she gave a description. Michael Johnson also called 911, and he presumably gave a description. So they did have a description, and DeMarcus Ivy matched the description because we have lots of other evidence that he was also in Club Nicky's. So I'm not saying that this isn't suggestive, but there is, the Supreme Court has also recognized that there are times when suggestive show-up procedures are helpful. When you do have a crime like this, a murder, and you need to find the suspect, it may be okay, it may be better for them to go ahead and show this person so that he can be released if he's not the person and they can find the person that did it.
Well, this is clearly not a case that he would have been released. If someone said, he doesn't look anything like him, based on what you said you found in the car, would it?
Judge Gregory, I would say this, because at that point, we didn't have the ability to connect. The only thing that I think they would have known at that time was that the hoodies generally matched, that there was Big Mike's phone because they were able to turn that on relatively quickly. But I don't know if they knew that Randy Hamilton, the wallet, connected them. I know they hadn't gone through the video procedure to see
12 people did not identify him and he was not released.
Well, 12 people didn't identify him, which also goes to the point that how suggestive could it have been? If it was so suggestive, wouldn't more than 2 people have identified him? They didn't. So, I think that what I'm saying about whether or not they would have released him is they certainly didn't have the quantum of evidence that we now have and that we can rely on for a harmless error argument. They only had some of it. Whether they would have released him or not, I do not know, but they certainly might have if nobody had identified him. They may have been forced to.
Mr. McLaughlin makes a good point when he started off. He said, listen, you have a situation where we know this is a dangerous type territory of show up identifications. But if you keep on having these cases where you never really enforce it, then it never gets enforced because you come in and say, well, it was suggestive. But look what else we had. And look, we had here. But here, this case, it's I would say it's very suggestive. And then, of course, you have these other things that are there. Like you said, you didn't know you were going to have those. And then every case gets sort of better later on anyway. It sort of not cover up, but supports the other things. Because like you said, you didn't have that. So later on, you say, well, look, we had this anyway, so then it's harmless. So we never really get to really give a fair assessment of the impact of suggestion because it's a moving target because your case, rightfully so, gets better and better and better and better and better.
Well,
Right?
or it gets worse, I mean, or it gets worse and they don't get prosecuted. It could go either
But we always
way.
get the cases where it gets better because otherwise, if it got worse, it wouldn't be here.
That's
what
right.
I'm saying. That's what jurisprudence can only face what comes to us, and it's always when it wants to get better. And then you say, well, maybe it's suggested, but look what we had here. There's no harm, no foul. And is that a real way to protect the constitutional type protections by using that formulaic type reason to justify it?
Your Honor, the Supreme Court has made very clear that due process is not implicated by a suggestive procedure. Due process is only implicated if there is a substantial risk of misidentification. And this procedure was not as suggestive, yet there were suggestive elements to it for sure, but you also had an officer who told each particular witness, don't identify him unless that's the person, because if it's not the person, we need to know that.
Well, I tell you,
That makes it a lot less suggestive.
whatever you had, if you weren't secure enough to go with your case at trial without those identifications. You had you had all those other things, the cards, you had the money,
Sure.
you had the hood. You knew that you needed those identifications.
I don't agree with that, Your Honor.
You don't think so? Okay.
No, I don't. I think that, and I will say this, what a trial attorney thinks they need and what I think they need may be two different things, and you'll probably appreciate that distinction.
Right.
All right, but I will say that, you know,
Well, I didn't mean you. I meant, of course, the government. You're trying the case.
right, but I'm saying as the appellate chief, the appellate person who defends my colleagues' work in the trial court, I can regularly say you overtried that case. You didn't need the evidence that I might be going up defending the admission for. In this case, we didn't need this identification evidence, and in fact, I think that the defendant did quite a good job of attacking that on cross-examination, and that's part of why there's not a due process violation here. They had the fair opportunity to challenge the accuracy of that. I do want to briefly address the suggestion that Dr. Michael was somehow, first of all, obviously that issue, I'm sorry for saying, I shouldn't say obviously. We believe that he waived the issue of the expert testimony, but I also want to note that he wasn't saying anything that all of us don't know. In cross-examination, we asked him, so what you're saying is that if it's dark, it's hard to see. If there's an obstruction, it's hard to see. If you're nervous, it may make your identification less reliable. Everything that he was going to testify to is something that jurors would know. And this court has been very discouraging of eyewitness expert testimony talking about eyewitness identification. This court's decision in Lesbier is one of those. I want to turn to, unless your honors have.
Quickly, his co-defendant, the co-defendant testified that appellant here was the one that shot Mr. Youngblood, or no?
His co-defendant did not testify.
Right, well then what's the evidence that appellant shot Mr. Youngblood?
Both Michael Johnson and, well, three witnesses who were present testified that the shorter of the two assailants shot him, but also he's guilty under.
Two of those three were the ones involved in this show-up procedure, correct? Johnson.
Yeah,
and
they had the
Simmons?
best look at him. Yes, both of them saw him by the.
And who was the third one?
The third one was Randy Hamilton, who was sitting right next to Mr. Youngblood when he was shot.
Was he also taken to the show-up procedure?
Well, I assume. I don't have There's no evidence in the record that he was taken, but I would presume that he was unless he left and said, I suppose I should say I don't know.
He didn't identify him, right? There's only two.
Right.
But at the trial, he got better, his memory got better?
No, what he testified to, Your Honor, was that the shorter of the two assailants, and that's what I was trying to get that out. With the shorter of the two assailants was the shooter.
Okay, so he was not able to identify Mr. Ivy as the shooter other than the shorter of the two assailants was the shooter.
He did not identify him at trial by vision.
Was not asked to, correct?
He was not asked to. And I don't know whether or not he was brought to the show-up identification. What I do know...
Since he wasn't asked to identify him at trial, maybe that is some indication.
But I wouldn't be surprised if he could not identify Mr. Ivy based on his face. What he knows is the shorter... Pardon me?
Wasn't he standing right next to
He was sitting next... Okay, let me go back. If I could, just get a couple things out, Judge Thacker. First of all, there were only two witnesses that we're aware of who saw Ivy DeMarcus under good lighting conditions. They were Brittany Simmons, who was by the bar when he first came in, and she tested by the cash register, and there was light that was shining down. Michael Johnson saw him by the cash register and in the lobby. Randy Hamilton was in the dark part of the club the entire time. He was at the back initially, and then Mr. DeMarcus brought him up to the front and put him on the floor next to Adrian Youngblood, whom he shot. And what every witness testified to, and what we know from the two people who were found in that truck, is one was 5'8" or from somewhere between 5'9", 5'10", and not particularly large, and the other one was much larger and larger in every way. And so these were not close.
How tall was he? You gave 5'8", 5'9", 10.
I don't know his exact height. I mean, I could look at the pre-sentence report and tell you, but there was one, all the witnesses, every single one said there was a shorter one and there was a taller one. And I do know that Mr. Bishop was heavy set.
So Mr. Bishop did not testify at trial. I
Did not.
assume then that somebody testified as to his height and weight at trial?
I think there was some testimony by one of the officers who seized Mr. Bishop about his size.
Because otherwise,
And-
how do you know who's the shorter one?
Well, you can see it in the video, Your Honor.
Okay, the video.
You also have video surveillance that shows them both.
Okay, can I go back to so there's three, so there's Simmons and Johnson.
Both of whom saw him in good lighting conditions. And then Mr.
those
Hamilton.
were the two that were taken to
What-
the car.
There were 14 witnesses
Right,
taken.
but I'm just
Those-
focusing on the three. I'm trying to find out if there was sufficient evidence absent the identification
Yeah.
to convict him of the murder, whether this was harmless or not. So I'm trying to just focus on those three. Those two were the ones that showed up at the two of the 14 that were taken down there within the 2 to 4 hours afterwards. And those are the only two during that process that identified him. And then Hamilton did not identify him and wasn't asked to at trial.
He
Correct?
wasn't asked to at trial, and I
But
don't...
he just said he's the shorter one.
He did. He said the shorter one shot him. But to be clear, Mr. Ivy is guilty either way, because there's an aiding and abetting, and
I looked at that.
there's... Yeah,
In the
it was in...
indictment?
Pardon me?
In the indictment, there was an aiding and abetting?
I don't know if it was in the indictment or not, but it was instructed on and nobody objected to it. And so it was absolutely, the jury was instructed that they could find on an aiding and abetting theory.
I looked at.
But the evidence that it was Mr. Ivy was very strong. You also have the agent who did the video assessment as an expert testimony was able to isolate which people were where, and he was able to isolate that the person who was wearing the clothing with the characteristics that Mr. Ivy's clothing, taken off of Mr. Ivy the night he was arrested, that he was the shooter. You could see it in the video that he was the one. And you know, if you watch this video, and I see that my time is up.
You're doing great.
It was a shooting that happened as they were walking out the door, and he turned around and shot him. So he was able to isolate which was which, and based on the clothing as well. So we had a lot of that evidence. Your Honor, I didn't get to address the Miranda issue, I would say that for that whether or not the questions that were posed were, did you get run over by a truck? Did you get hit by the truck? And that those were not reasonably likely to solicit incriminating information. But even if it was, we had so much evidence that it was Mr. Ivy in the truck that would be harmless. If your honors don't have any other questions, trying to remember if there's anything else that I need to say, but I think that if your honors don't have any further questions, the other evidentiary issue I would also, I do want to address Mathis. Yes, Hobbs Act, thank you. This court's decision in Mathis holds that Hobbs Act robbery is a crime of violence, a completed Hobbs Act robbery. And Mr. McLaughlin's arguments contrary to that are simply challenging the legitimacy of Mathis. I mean, he doesn't make any particular argument other than based on Borden that you could commit it by recklessness, but you can't, under Mathis's definition of Hobbs Act robbery, it can't be reckless because it requires a threatened use of physical force or actual force. So in light of this court's decision in Mathis, it cannot be plain error because plain error requires a decision that shows that the decision was wrong, and Mathis shows exactly the opposite. If your honors don't have further questions, the government requests that this court affirm the district court.
All right, thank you. Thank you. Ms. McLaughlin?
Thank you, Your Honor. First, I would note with respect to, Ms. Simmons, she stated at various times, and it's in our brief with record sites, that the shorter gentleman's face was covered, implying she couldn't see it, that she had seen the left side of his face, then she changed that. She testified that she was facing the door when the assailants entered. The video establishes that she wasn't. She was looking in the other direction. There are some significant issues with respect to the reliability of her testimony. If you eliminate those two, and of course we're beyond a reasonable doubt, the testimony you have is Mr. Hamilton saying, well, the smaller guy did it. That does not get you a conviction beyond a reasonable doubt anywhere.
With the other two, I'm not entirely clear on, did they also testify with respect to the murder, with respect to the shooting, that the shorter of the two had the gun and shot the gun, or did they make a comparison like that?
I don't recall, Your Honor, one way or the other. I don't recall that, but I can't reliably say that they didn't make reference to that. What I think is also relevant with respect to that question is with respect to the clothing and all of that, it was generically dark clothing. And to the point that there was a connection between Mr. Ivy and the truck, I think without the question of were you hit by the truck, you have really the connection is the issue of the DNA analysis, which simply put him in the clothing in the general category of consistent with his DNA, not saying it was, which leaves open a variety of arguments available to the defense. And so you get to a place where the standard of beyond a reasonable doubt really comes into play in a much more significant way. I would like to address briefly the issue of the Hobbs Act because the government is correct. We are saying quite simply that Mathis is wrong. And if you look at and understanding the procedural hurdles we have there.
A panel, we can't reverse a panel, publish opinion.
You're right. I need to preserve the argument so that I can then seek a petition for a rehearing en banc, although...
Everything you put in your brief is preserved, counsel.
Yes, you're right. I would suggest in its decision this court could note that there are concerns about Mathis.
Counsel, good. I'm sorry for disturbing you. Go ahead.
No, that's okay, Your Honor. Certainly. I appreciate the guidance. This court in its decision could say it has concerns about Mathis that would raise issues. I just want to make note of the recent decisions. So this court's decision in Malacu 41F 4386, where an injury to property can be committed without the use of force or the threatened use of force or violent force. If you look at Hobbs Act robbery, it is fear of danger or damage to property. And most pertinently, we don't have to jump through a lot of theoretical hoops here, because if you look at the cases that we cited in our brief across a variety of circuits, there are a host of cases where there is no credible argument that the defendant threatened force or used force or attempted to use force. But nonetheless, because of the fear component, the court said it was sufficient that the bank clerk or whoever it was felt fear, and that is sufficient. And it's a very broad reading of the Hobbs Act robbery statute. Again, we've identified at least half a dozen cases in our brief. And our position is you cannot have it both ways. You cannot have such an expansive reading of the Hobbs Act robbery that once someone is just in fear simply because, for example, someone walks in the room and says, put money in the bag, with no threat, no evidence of a weapon, no effort or interest to commit violence, and then call it a crime of violence where you have to have the use, threat, or attempted use of violent force. And those cases, very concrete cases, are completely inconsistent with the expansive view that you have. The other thing is the recent cases, particularly, I think, if you look at Battle and if you look at Castleman and this issue of the directness and the use as an instrument of violence, whatever the extent of the violence is, you go back to the cases we cited in our brief and you don't have that. And so I think there is a legitimate argument there that the court here could recognize.
Of course, you're referring, of course, to the categorical assessment of it, the crime.
Exactly, we still have category. Lastly, I would just say on the issue of the show-up identification, Your Honor's point that, the case always gets better or I apologize, my time is up.
Go ahead, you can finish your thought, go ahead.
So if the government is correct, there just aren't cases where courts say no. And so, you engaged in this post hoc analysis of, okay, let's look for reliability, let's look for something that's not suggestive. The notion that in the totality of the circumstances here, saying at the front end, this person looks like the suspect, and putting all that you have here, man in handcuffs and the rest of it, that it's all forgiven because we said, well, it might not be him, so please, just be careful about that. And the actual statements from Detective Hopkins are considerably less forceful in the testimony than the government, I think, recalls. But that is a fig leaf. And at some point, you have to say, no, a fig leaf is not enough. And so you have to say, okay, are we going to give up saying that show-ups are not a problem? Because every time we look for some excuse to say, well, maybe it's reliable because there's other evidence, so we're going to continue to allow it. Or are you going to say, no, this is suggestive and there are issues about reliability of that here, particularly, again, where you have the police saying, in a beyond a reasonable doubt case, when 12 people say that's not the person, I can't identify them, and one says, well, it looks like him, and the other is completely inconsistent. If you were trying this case just on that identification evidence, Mr. Ivey would have walked out of that courtroom. He was not convicted in the state court. It was a hung jury, which is why we wound up in federal court in the first place. So there's actual tangible evidence here that but for some of these issues, the result in the trial would have been different. Thank you.
Thank you, Ms. McLaughlin. Thank you, Ms. Ray. And Ms. McLaughlin, I note that you're court appointed, and on behalf of the Fourth Circuit, I want to thank you so much for doing this. Our court relies on lawyers like yourself who take these cases, and it's very important. I want to thank you very much. And of course, Ms. Amy Ray, we thank you for your able representation of the United States. And counsel, I hope you don't mind this, but we can't come down and shake your hand and greet you. But if I could, I would add one addition, so I'll let you hear what I would say to Ms. Ray, and that is, had nothing to do with this case. Congratulations on it's very nice. I read that she's taking on her civic responsibility in terms of schools in her town, and she's on the board, and thank you for that service, and congratulations on your win. Counsel, that, all right. Thank you so much. We'll go to our last case. Thank you.
Good morning, Your Honors. May it please the court. Melody Busey on behalf of the petitioner Maria Gonzalez-Lemus. The immigration judge and the BIA erred in their decisions to deny her application for asylum, withholding, and CAT. Now, before I go into the two primary issues that this court wants to address, I want to briefly just go into the facts of the case because I do think they're very relevant to the PSG, and I'll be very brief as to the facts of the case. The petitioner is a 36-year-old citizen of El Salvador. In June of 2015, the petitioner was threatened by a gang member when he approached her at her house and asked her to pay extortion rent because she was working at a business that belonged to her sister. When she said no, she does not want to pay the extortion rent, he then subsequently told her, I will harm you, and then just left it at that. Fast forward 2-3 weeks later, and sometime around June of 2015, as she's coming back from working and she's going into her house, a man approaches her from behind her, puts a hand around her mouth, tells her to go in, and proceeds to rape her in the very spot that she was threatened 2-3 weeks prior. And then after he rapes her, he then says, if you report this to anyone or to the police, I will come back and rape your 11-year-old daughter. For those reasons is why the petitioner and her daughter eventually came to the United States. She did, prior to coming to the United States, she did relocate to another part. I believe it was 3 hours away from where she originally was raped. But she ultimately felt that she was not safe. She was living in constant fear that this person or other gang members were going to come back and rape her 11-year-old daughter.
Is her sister still in El Salvador?
Yes, Your Honor.
And has she been harmed?
No, not to my knowledge.
And didn't petitioner testify that she didn't know if she would be raped again if she went to El Salvador?
She did testify to that fact. She couldn't say for sure that she would be raped, but it was the threat. It was the fact that.
Right, it's a threat.
Right, and the fact that she was already raped. So it wasn't an empty threat. You know, she was already raped. So she has that past trauma, and then you couple that with the fact that they said that he said that he was gonna rape her 11-year-old daughter. I mean, that is tremendous. I personally would be afraid. And so she did try relocating, and she did testify at her merits hearing that nothing happened to her when she relocated 3 hours away, but she was living in constant fear. I mean, she testified that she picked up her daughter from school, would take her daughter to school. She wouldn't leave her daughter alone. And they pretty much just stayed inside their house, except for necessities, school, food, water. She pretty much didn't leave because she was just terrified of the thought of her daughter being raped as she was raped.
So the IJ in making the CAT ruling said that the court finds it's an unsupported assumption that respondent will be harmed in the future and that it amounts to speculation. What's the evidence that requires us to disagree with that?
Well, Your Honor, first, the evidence is the fact that she was raped previously. So that establishes past persecution. And in this court,
But the IJ didn't didn't conclude that, right? The IJ found that her testimony wasn't corroborated on that point.
Right, Your Honor. And respectfully saying, I think that that analysis, that finding was nonsensical because of the amount of evidence submitted. So on one end, the judge says.
Did you raise the corroboration issue in front of the BIA? They have a footnote saying that they're not going to address it.
So I will get to that point right now, Your Honor. So the government is arguing that we failed to exhaust the corroboration issue on the BIA level, but we disagree. And the main reason for that is that, in a way, the BIA conceded to that issue because in the decision, in the footnote, they state that we did not meaningfully challenge the issue of corroboration. They didn't say that.
That you raised it because they conceded to it?
Well, I'm saying that they already agreed that we did raise up the issue because they said that we didn't meaningfully bring it up, meaning that we didn't.
Where did you bring it up at all?
So we did.
Where's the word corroboration anywhere in petitioner's brief to the BIA?
I believe there's one part, it's administrative record, I think 26. I don't have the exact page, but there is one part where we do bring up corroboration, specifically the word. But what I.
You thought it was 26?
26, Your Honor.
Isn't this whole thing about whether you raised corroboration or not before the BIA? And you don't know where I can find that in the record?
I do have it, Your Honor. It's in my notes, but
Okay, well then maybe when you get back up, you can tell me.
All right, thank you, Your Honor. But we did raise the issue of corroboration in essence throughout the brief. We may not have underlined it or bolded it or dedicated a whole section, as I will concede we should have. I don't know why we didn't, but we did raise up the issue of corroboration in essence as a whole in the brief.
Just tell us what you did.
Okay, so we discussed the country conditions. We discussed the petitioner's credible testimony. That should have been alone corroboration. I mean, this court has held that before in other cases.
The fact that you cooperate, you're saying is that because rape and women, it's unfortunately very prevalent, correct?
Correct, Your Honor.
And you put that, and you told them that, correct?
Correct.
So that corroborates
It does
what
indeed.
happened to her. Maybe it's not unusual to other people as well. That's corroboration, I guess, right?
Correct, Your Honor.
What else did you have?
And then we also mentioned country condition reports, and that is a form of corroborating evidence, and a form that the immigration judge, did not really take into consideration fully or completely, kind of glanced over it and just said that there's generalized violence and crime throughout El Salvador, and so in discussing that is discussing corroboration.
Because people normally, usually raped with an audience.
Precisely, and then they're not subsequently threatened that their 11-year-old minor daughter will be raped as well,
Right.
After you were raped in the very spot that you were threatened 2-3 weeks prior, which I think is, important to note because they made a point with that to come back and rape her in the very spot that they threatened her.
Right.
But to go back to Judge Rushing's point that, the issue of exhaustion as it relates to the issue of corroboration, it was in essence discussed in the brief entirety. It wasn't eloquently put, I will say. We didn't put it, like I said, underneath a header, underlined it, bolded it like we normally do, but it was in whole throughout the brief. It was discussed by her credible testimony, which is corroborating evidence. It was discussed by the country condition reports, which is corroborating evidence. And it was also discussed in the affidavits, specifically the partner's affidavit. He did address the rape claim, in which the immigration judge said that none of the affidavits submitted even talked about the rape claim. I will say most of them did address the petitioner's good moral character, but it's because she didn't tell anybody about the rape, and she testified to that. The only person that she told was her partner, who's here in the United States, and he wrote an affidavit and mentions the rape in it. So, one, I do feel like the issue of corroboration was exhausted in the brief. Also, in the notice of appeal, it does say that the petitioner will appeal the I-589 application. The I-589 application is the asylum, and so the inference there is that we're going to appeal all the decisions of denial for that application. The reason that the petitioner couldn't be more specific in the notice to appeal is because she, as indicated in there, she did not have the actual full written decision where the judge goes in detail with why his reasons for denial. She didn't have that before her, so then she could only put that I'm going to appeal, the I-589 application denial. And so why I bring that up is because there's a case that was decided last year in this court, Hernan Portillo Flores v. Garland, that specifically addresses if the notice of appeal at least says it in some way, shape, form. It doesn't have to say the magic words, but in some way says it in the notice of appeal, and then the BIA goes on to address it, then this court indeed does have jurisdiction to hear this claim, and it was exhausted.
But the BIA did not address it in your case.
They addressed
The
it,
BIA said it was waived.
right, in the footnote on, I think it was page 2 of the BIA's decision.
The BIA did not address it in this case, so
But,
that's
Your
a
Honor,
distinction.
on page 3, I believe, of the decision, towards the end, I think it's one of the last paragraphs, the agency does briefly mention cooperation. It was as it relates to if she could reasonably relocate. The BIA said that she failed to provide any corroborating evidence on that issue. That is, in a way, the agency preserving that issue. They may have not had a full discussion of cooperation, but they did raise it up towards the end.
You're saying the agency preserved the issue, but they did not address it on the merits, correct? Or are you saying that that?
They addressed it, they addressed it kind of in part. So they didn't have, it was kind of the same way we addressed it in the brief. So they addressed it in essence as well. So they put the footnote saying that we didn't meaningfully exhaust that issue. But then on page 3 of the decision, they go on and talk about how we failed to provide any corroborating evidence as to her being able to
page
reasonably. Yes, Your Honor. And so all that coupled, so the fact that they did say that we didn't meaningfully challenge it, I think there's an inference there that means that we did challenge it, just not to the
You did,
agency standard.
you had the evidence that from the boyfriend, that he wrote the letter,
Yes, Your
and
Honor.
they had that. But also in terms of cooperation, in terms of ability to move, it seemed to me that in this case, she did, because what she's saying is that she's brutally raped in her home, and then the assailant turns around to her and says, listen, you shut up, because we come back, it won't be you. It'll be your 11-year-old daughter. I cannot think of anything more chilling to a mother to hear that. And you say you can go someplace in the country and you're going to lose that incredible trauma of a rapist telling you, I'm coming back for your 11-year-old daughter. I wonder what part of any country you could go to and ever feel safe about that.
And then to that same point, Your Honor, it's El Salvador. She's from El Salvador. We are all well aware of the country conditions in El Salvador. And if we are not aware, there was numerous country condition reports submitted, almost 300 pages worth of evidence submitted indicating and explaining just how bad gang violence is in El Salvador. So even if she could move 5 hours away from her home, gangs are prevalent all throughout the country, and not just in El Salvador, but Central America as a whole. So for the judge to expect her to just move 3 hours away and live in peace when with the threat of her 11-year-old daughter being raped, not just harmed or hurt or they threatened to rape an 11-year-old little girl.
The other thing, see, the evidence is that they grossly misunderstood the human nature of it, said that it was not meaningful cooperation. Because that's the essence of this game. They came to her home, they know where she is, and raped her. And then to come back to your daughter and talk about this is a case, this is not where your political views, you can go someplace else with people who think like you could do that. Where can you go in that small country with all the gang violence? That's not general gang violence. Here we're talking about specifically she was raped, and they didn't question her credibility that she was raped, did they?
No, they didn't. And in fact, the immigration judge found that she was credible. She was credible. And then if we want to go backwards a little bit, when she first entered the United States, she had a credible fear interview, and she was also found credible at that stage. And then the judge goes on and says, I must find her credible. He says something to that effect. I must find her credible, even though she testified with a flat tone. And I'm really unsure as to how is that relevant, because she's a rape victim. Is he trying to say that she's supposed to testify in some sort of way conforming to how all rape victims are supposed to be? I mean, rape victims, it's different. It's
Unfortunately,
different.
many of them are just silent.
What was that, Your Honor? I'm sorry.
I said, unfortunately, many of them are just silent.
Mm-hmm. And this is why,
Voiceless.
and this is why this court constantly hears asylum cases, constantly because immigration judges are always doing this. They ignore credible testimony. They go on to find the petitioner's credible, but then says that she lacks corroborating evidence. It's almost contradictory. It doesn't make sense. And then in this case in particular, she submitted an abundance of evidence. If I had to say if there was one piece of evidence missing, it would have been a police report. But she gave a reasonable explanation for that because her daughter was threatened right after she was raped, but right after the petitioner was raped, and her daughter was threatened of being raped if she went and told the police. That is a reasonable explanation for why there isn't a police report. And then on top of that, she even further stated that if you report stuff to the police, oftentimes police end up missing or you find them dead because of the corruption in El Salvador and the commingling. Either police are afraid of the gangs or they work with them. And so she gave a reasonable explanation as to why a police report was lacking. And then everything else goes in her favor. She had affidavits, one from a person most close to her partner, that addresses the rape. It addresses it briefly, but it does address the rape. And the country conditions reports all support that there is gang violence all throughout El Salvador, especially towards women. They oftentimes just dispose of women like animals. The country conditions support it almost on the spot, Your Honors, and yet the judge goes and says there's not enough corroborating evidence. It almost seems like it was a catch-all for him to deny the claim. Your Honors, I do see that I'm running out of time, and I need to address PSG, so I'm going to reserve my last 5 minutes so I can address PSG if you don't have any other questions.
That's fine. Thank you, Kelly. Ms. Ben?
Good morning. May it please the court, Arthur Rabin on behalf of the respondent, the Attorney General. In this case, the court should dismiss in part and deny this petition for review in part. Starting with some of the jurisdictional issues, the court does not even have to address the asylum and withholding because of exhaustion and jurisdictional issues. First of all, as to asylum, this was not a timely filed asylum application. And this court has held it has no jurisdiction under the statute, which specifically prohibits such jurisdiction, to review the timeliness claim. That is, whether or not an application was filed within 1 year of arrival is not within this court's jurisdiction to review. So asylum on that ground alone is off the table. Number two, the corroboration issue. All courts are very clear, including this one, that you cannot just generally raise an issue. You have to be specific, which is why the court said, the board said you didn't meaningfully raise the issue of corroboration in your brief, because what they did raise in their brief, they meaningfully did, which is the issues of the 1 year bar, the PSG, whether or not something was a particular social group.
So what about her argument with regard to Portillo Flores and the fact that she says she raised it in her notice of appeal, sufficiently raised it in her notice of appeal?
It was not specifically raised in the notice of appeal, Your Honor, because what the notice specifically said is that it was a very broad one-sentence statement that said, respondent desires to brief the denial of her I-589 application. That's it. That's the entirety of her claiming that she raised a claim, an illegal argument against corroboration, which is in their briefing to this court they did. Yes, it's very well briefed, but not to the board. And the whole point of exhaustion is to allow the agency.
So how do you distinguish our holding in Portillo Flores with what happened here?
Well, Your Honor, what happened here is that when you just raise a broad claim, how does that put an agency on notice of what your specific argument is to allow the agency to address it? You cannot just make a broad claim and say.
And, well, the agency, according to opposing counsel, did address it in their opinion. I think it's actually on page 2.
Page 2, Your Honor.
Where it says, that she, respondent provided little corroboration that she could not relocate and that she was not able to identify her attackers or their gang affiliation. So arguably the BIA did address it in their opinion.
Your Honor, I think an important distinction needs to be made, that there's a little bit of confusion here. Under the asylum statute, there's two burdens of proof. One is the burden of going forward, putting forth sufficient evidence. Credible evidence, corroborate if necessary. That is your burden of production. Then you have the burden of persuasion of meeting the elements of asylum. That is, whether or not there was past persecution or well-founded fear on account of a protected group with a nexus that caused the mistreatment. So we're talking about two different things. So what the board was actually addressing was the relocation issue, which is part of her prima facie case for asylum, not her burden of production to meet the immigration judge's concerns about her credibility. What the judge said, look, I find in several footnotes that her testimony is inconsistent. And I'm specifically talking here about footnotes on page 2 of the immigration judge's decision, page 50 of the record, as well as he noted that her testimonial demeanor was very poor and that it needed to be corroborated. The judge indicated that her inappropriate laughing when discussing some of the most traumatic parts of her testimony seemed to be, and this is on page 5 of the immigration judge's decision, page 53 of the record. She had a flat effect, little emotion about the graphic and traumatic events, and the respondent laughed when asked about her fear of returning to El Salvador because she was raped. Under those circumstances, the immigration judge felt that, as the statute requires him to do, to ask, well, okay, this seems to be a little bit inconsistent here, and maybe he, even though he didn't issue a full-on, I don't believe you, adverse credibility finding, what he did say was, I think under these circumstances, corroboration would be required. And that he discussed fully over 1.5 pages. But that, none of his discussion and those reasons were actually addressed in either the notice to appear or the brief to the board. So we would argue that is not exhausted. So now, because corroboration deals with her claim for asylum and withholding, neither of those are before the court and should be dismissed for lack of exhaustion. But briefly to move on, if the court does deem that the issue was corroborated, there are a plethora of grounds that the agency used to deny this withholding claim. And asylum was time barred. So the board found that not only did the proposed social group of single women who oppose or are perceived to oppose gangs and that they are unable or unwilling to make extortion payments was not legally cognizable, but that it had no nexus to a protected ground. That nexus finding also was never addressed by petitioner to the board, even though the immigration judge fully discussed it. So that also was not exhausted because it was not raised to the board. So now we know there's two more, so now there's corroboration and nexus, part of her prima facie case, to demonstrate that she was persecuted on account of a protected ground. She never addressed to the board never addressed so that this court could review it. Moving on to the actual whether or not this was a cognizable particular social group, the agency found that there was just insufficient evidence put forward to show that single women who oppose or are perceived to oppose gangs and that they are unable and willing to make extortion payments, that it lacked immutable characteristics, particularity, or social distinction to show that this was a group that had clear benchmarks and that this was an immutable characteristic that she could not change or should not be permitted to change. Now, single women, she could become married. Although women, obviously her gender is immutable. However, her inability to pay or her not willingness to pay could be changed, so it is not immutable. The group is not sufficiently particular, the agency found, because it lacked clear benchmarks for determining who's in the group. Obviously, Salvadoran people, their ideas of what is, who is unable or what actually constitutes inability to pay, given how many people the background country reports show are actually subject to extortion by the gangs. Salvador may not agree on what level of opposition needs to be required, what actually constitutes opposition, what is the actual extortion. So that's not a sufficiently particular group. And as far as social distinction, there has been zero evidence put forward that as a society, people in El Salvador view this particular social group as a distinct group, meaning that there's no evidence in the record to show that single women who oppose or are not able to pay extortion demands are a distinct group within that society, given how widespread extortion is in that society. Moving on to the relocation issue, just very briefly, even if petitioner can show all the other elements, and this court sustains her claim on all the other elements, regardless of jurisdiction, she has to show that she could not relocate within her own country. Now, I know, Judge Gregory, you expressed concerns about what kind of person could move once that threat is given. The threat, the actual threat, factual threat was not that she needed to pay, and then if she didn't pay, they would come back and rape her daughter. No, that was not. There was no linkage to the extortion demand. The rape, which happened 3 weeks after the extortion demand, was never connected. She never said that I identified the same man who made the extortion demand as the same man who raped me. She never said he made any statements whatsoever referencing the prior threat to link the two. Instead, what he said was, if she told anyone about the attack, the police or anybody else, then he would come back and attack her daughter. So what this criminal was actually worried about is not that she not pay, not that this was retaliation for her not paying, but that he would be found out for the crime of rape. That's what the threat was about. And then it actually shows that she was able to successfully relocate to her parents' house, which was 3 hours away, and lived there with no harm, no threat of harm, and no member of her family was harmed, including her sister that actually owned the store where the extortion demand was made. And to this day, there is no evidence whatsoever that any member of her family has been harmed in El Salvador due to the failure to pay the extortion demand. Finally, the two issues, torture convention, petitioner did not demonstrate a key element of what torture convention requires, which is that the burden she has is that when she would be returned, she would be tortured by or at the instigation or with the consent or acquiescence of a public official or other person acting in official capacity. Now, the agency also made another finding, which was never addressed, which is that the threat of actual torture is very low. And that is because when asked, directly asked, do you fear harm when you go back? She said she didn't know. No member of her family has been harmed, and she was not convinced because there has been no ongoing threat. No one's come to her family members to say looking for her or threatening her. So she cannot, other than speculate, indicate that she is subject to some kind of threat of torture.
As the cat claim, do you concede that she has evidence of past persecution? You think rape is persecution?
Yeah, I mean, Your Honor, yes, rape is definitely persecution, but it's not necessarily torture, which is what we're talking about. So the persecution is for asylum withholding. Torture is specifically defined in the regulation as something else other than persecution. So
rape is not torture.
Well, no, I'm just saying that the act of rape,
that's what you just
it
said.
could be.
No, wait a minute. Did you say that? You said rape is not torture.
What I'm saying is I'm trying to define for you the terms of what the statute uses.
I want to make sure you said rape is not torture.
If I did so, I misspoke. But what I am trying to say, Your Honor, is that I said it may not be persecution and torture are two different things under the statute.
But so that's what I'm asking. Rape is torture, isn't it?
Whether or not it's a prior act of torture, she has to show that more likely than not, she'll be tortured in the future. Now, what evidence
Is that
has...
credible fear when somebody rapes you and say, listen, I'm coming back for your daughter?
Your Honor, credible fear is not the standard.
I know, but the standard in terms of fear of torture, correct?
The standard is that she has to show that it's more likely than not, that clear probability that she would be tortured if returned to her home country.
So again, I think you're trying to skate it. You don't believe rape is torture, do you?
Okay.
Because you keep saying that. Right? Is that right?
No. Rape, On the record, I'm saying rape can certainly constitute torture, Your Honor.
Okay, all right. So you
Okay,
say,
as a
so
prior-
she has had past persecution, and not in terms of torture, as a cat claim, right? She's had past. It's happened to her, correct?
Yeah, it has, and it could be an indication of whether or not she will be tortured in the future.
In our
Certainly as a
jurisprudence, is that a
factor.
presumption for that it may happen in the future at all?
No, there is no such presumption under the CAT regulation.
Okay, all right.
Okay, there are factors, including past torture. That is a factor to be considered, which the,
One of the factors, the person who committed the torture is in the gang.
one of the factors is how widespread the risk of torture is in
And
the
the fact
country.
that the person who tortured her is in the gang, is a gang
We don't
member.
know what gang, we don't know how widespread this gang is. We don't know if the person
The
who
country
tortured her
reports
was
say
in the
how
gang.
widespread gang violence is in the country.
Your Honor,
You want to have it, you want to have everything in your way just to, I mean, to say that this person does not get relief. Oh, yeah, well, yeah, it says that, but which gang was it? It's replete with the country reports in terms of how widespread it is. It's replete. This is not someone where this was someone they had a familiar relationship with before, or ex-boyfriend, or isolated situation that led to this rape. This was a situation that was clearly a gang, and that's undisputed in this record.
it's not that clear, Your Honor.
What's not clear?
It is not clear that she was
raped is
raped
not
by a
clear.
gang member. There is no evidence she was raped by a gang member.
But that's
She
her
said
testimony,
she
she
couldn't
believed.
identify him, and it was not the same person that threatened her. She could not say that.
That's why.
So
That's why
whether or
it's
not
called
this was-
gang, because there tend to be more than one person in them.
Your Honor, maybe, but we're speculating now. We're in the realm of speculation as to what happened. I'm trying to discuss what the evidence is. The evidence here is
In the
what
case
she
of the Fourth
testified.
Circuit we've had in terms of people being threatened. Go ahead.
Your Honor, I submit, Your Honor, rape is torture. Absolutely is. It is, whether or not it rises to the level of future torture, it's an indication that she might be future tortured back home. But since there's no ongoing threat,
And in
the
this
gang is
case,
not looking for
There was
her.
a reference to a future rape, correct?
There was a
daughter.
reference,
Her daughter.
Your Honor, if she spoke to anyone about the rape,
And
they
wouldn't it-
threatened, or the person threatened to rape her daughter.
Well, in her returning to the country, isn't that logically, it makes common sense that there's more of a chance that it may be identified and implicated in that rape? It would have to be, wouldn't it? That's the person raped. They're back in the country. Wouldn't that, just common sense, increase that risk that they would be found out? And then maybe, I mean, I don't know.
Yeah, I don't know. There's a lot of contingencies there, Your Honor. That's a lot of speculation. So,
I guess not. I suppose so. It's like you rape somebody and they later on, 2 years later, move next to you or into your town. You don't think that there'll be a likelihood that you may eventually somehow find the courage to say what happened to them, and you may have to answer to some call of justice. You don't think that's common sense? That increases that risk?
I don't know, Your Honor.
Okay.
I don't.
All right, okay.
I
You
can
don't
only
know.
discuss what's in the evidence. So last issue here, Your Honor, is the motion to remand. The part of the brief that was filed with the board had a motion to remand based on a filing that petitioners made with the USCIS. It was a Form I-360 that indicated that an application for special immigrant juvenile status had been filed with the agency, but the only thing filed with the board as proof was a notification saying we had a notice of filing. Not the actual application, not the required court order, which would serve as the substance, or any other evidence for that motion. So the board, in this case, said you did not meet prima facie eligibility for remand because you didn't show that you prima facie are eligible for this kind of relief.
Is a motion to remand treated like as a motion to reopen? Is that right?
Well, Your Honor, no. What they actually treated it, they wanted a delay. They wanted to allow time to basically go back to the immigration judge to allow time for the USCIS to adjudicate the application for special juvenile immigrant status.
So the requirement that the application be attached to the motion, that requirement does not apply to a motion to remand? It only applies to motions to
Yeah,
reopen?
typically courts do treat motions to remand just like motions to reopen. Those are
That was
typically
Judge
treated.
Rushing's question in the first place, I thought.
Maybe I was confusing in how I asked
Yeah,
it.
I'm sorry.
I thought motions, thanks. I thought motions to reopen, or sorry, motions to remand are treated like motions to reopen when the basis is, I want to pursue this other new relief. And there's a regulation that requires those motions to be accompanied by the appropriate application for relief.
That's correct, Your Honor. All
Okay.
that is correct.
And that applies here?
Yes, Your Honor. Because what the board did is it said, we cannot grant your motion because you don't meet prima facie requirements for showing that you're actually eligible for the relief that you say you're eligible for. It's again, speculation that you would be eligible for this. So the board did not engage in any fact-finding. It has been alleged in the petitioner's brief that the board had engaged in unlawful fact-finding. What the board did was actually just assess the substance of the motion, whether or not the prima facie requirements were met for the special juvenile immigrant status, and said, no, it was not met. So there was no actual fact-finding in the board's decision. So just to conclude, Your Honors, it is the government's position that this entire case can be disposed of on a dismissal, subject to only the court's ruling on torture convention and the motion to remand, because the withholding and the asylum are not before the court because the vast majority of those issues are barred by either statute or the exhaustion requirements. Subject to the court's questions, that concludes my argument.
Thank you, counsel.
Thank you, Your Honor.
Ms. Busey, you have some time reserved.
Thank you again, Your Honors. Okay, so due to limited time, I want to just go ahead and straight into the PSG argument. Here, the PSG was single women who oppose or are perceived to oppose gangs and that they are unable or unwilling to make extortion payments. So the first prong that we have to meet to satisfy a valid PSG is a mutable characteristic. The mutable characteristics here are women, as the government pointed out. That's something that you cannot change or should not be forced to change. And then also shared past experiences, the fact that they've opposed gangs, that is a past experience, cannot be changed. So that prong has, in my opinion, been easily satisfied. And that was one prong that the immigration judge said was not satisfied. The second prong is social distinction and then defined with particularity. I say those together in the same sentence because they kind of go hand in hand. Particularity states that you have to be able to define the people, clearly define and set a benchmark for who fits in that group. And then social distinction typically is backed up by evidence, typically in immigration proceedings, country conditions, that in that the PSG has to be socially distinct within the community in question, so in El Salvador. According to the United Nations High Commissioner for Refugees, in areas where criminal activity is widespread and law enforcement is incapable of protecting people from gang violence, a person expressing opposition to gangs will often stand out from the rest of the community. That's Administrative Record 424 in the pre-hearing statement that was submitted prior to the merits hearing. And that statement right there goes to particularity and social distinction. So for the immigration judge and also the BIA to say that that the PSG was valid or invalid was just completely in error. There was reports submitted directly on point to satisfy the particularity and social distinction requirements, yet they said that they didn't even get immutable. The immigration judge said that the PSG wasn't even that, and yet clearly is. And it does meet the second prongs of particularity and social distinction in the country condition reports. Because in El Salvador, in a country that the government's not stable, you can't rely on the police to help you. You can tell, and also it's rampant with gang violence, that's evidence in country condition reports. You can tell very clearly the people who are with the gangs versus the people who are not with the gangs. The people with the gangs aren't really harmed. They live in impunity. And the people that go against the gangs.
On a different topic, were you able to find a JA site or a record site to where corroboration was raised by petitioner in her brief to the BIA?
It was administrative record, I have 4 in the last paragraph.
Administrative record 4 in the last paragraph. Thank you.
You're welcome, Judge Thacker. Okay, and then there were a couple other points that I wanted to address as to the PSG.
Sorry, I don't want to hold you up, but you say that's where the petitioner raised it in her brief?
What Judge Thacker just asked?
Yeah,
No, that was where.
that's where it's in the, that's
the
what you
BIA
said in the
decision.
BIA
Right,
decision.
I'm asking for where, thank you, Judge Rushing, where petitioner raised it in her brief so that it is not, so that we have jurisdiction.
Okay, Your Honor, let me just find that then real
Said
quickly.
there was a place where it was.
Administrative Record 26, Judge Thacker.
26.
Yeah, sorry for that confusion. Apologize. But going back to the PSG, something that the government mentioned is that all of her family is in El Salvador, or however many family members she has, and none of them have been harmed or threatened. That is correct, and that's because none of them were victims to rape, and none of them were threatened on the onset. So it stands to reason that they're being untouched right now because they're not the issue in question here. They weren't raped. Her sister was not raped. Her family was not raped, nor were they approached by the gang even. So they're not part of this particular social group. So bringing up that issue, it doesn't make sense because it's not relevant. The issue is her, the petitioner, Maria here. And does she belong into this particular social group? And was she raped on account of her membership in the particular social group? And she indeed was. She refused to pay the extortion demands. Now, I hear what the government has to say in that when the guy did come back and rape her, he said, if you tell this to the police, then I'll come back and rape your daughter. But it's important to note that she was raped in the very spot that she was threatened 2 to 3 weeks prior. So that is a nexus, that there is the relation there, that was the same person, and that it all relates back to her refusing to pay the extortion demands that they wanted. It is clear there. And she did testify in court that it was, she believes, MS-13. And she believes that it was the same gang member, but she didn't see them because, one, they were behind her, and they had some sort of stalking mask over their head. So, Your Honors, I see I'm running out of time.
Do you have anything additional to say about the cat claim?
The cat claim, Your Honor. So the standard there is that it's more likely than not that you will be tortured if you are returned to the country.
Notice that, I mean, to address the government's arguments, the Attorney General's argument about cat claim.
Okay, so
I mean, 'cause that's what rebuttal is. I mean, do you want to?
just briefly, Your Honor, I disagree with that decision. At minimum, cat should have been granted here because it was established that she was raped. That is a form of torture. Undoubtedly and unquestionably, that is a form of torture. And then on top of that, couple that with the threat of a future threat of her daughter being raped, that is enough to establish that it's more likely than not that she or her daughter will be harmed if they returned. And then on top of that, the country conditions support that. And I know that one of the elements for CAT is that you have to be able to, or the burden for the government is that they can easily relocate to another place. But that was discussed earlier that there's no other place in El Salvador that she can just safely relocate to and live a peaceful life without the threat or living in fear that her daughter might be raped one day. The gangs are everywhere, whether it's the same gang member that raped her or a different member entirely. Somebody can come and do that to her again or to her daughter. So to say that there isn't even a CAT claim at minimum here, that is an abuse of discretion, Your Honors. And that is a horrible finding and a horrible precedent for the judges, the immigration judge and the Board of Appeals to set. And for both agencies, the immigration judge and the board, to agree and to find that same conclusion is just, it's outrageous to even think of, Your Honors. If there's no further questions, Your Honors, I just want to say thank you. And the conclusion is that I think the decision should be vacated and remanded for a rehearing. Thank you, Your Honors.
Thank you both for your arguments. We can't come down and shake your hands, but we very much appreciate your arguments here today on these very important cases. And wish you well and stay safe. And we'll ask the clerk to adjourn the court sine die.
This court stands adjourned, sine die. God save the United States and this honorable court.